Good afternoon. Please be seated. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have time to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. For staff work. People v. Andre Harris. How much? 3 and 1 and 3. Vitali versus Kaban. Four and 2 and 4. Duran versus ERY, Retail Podium. He asked for 4 and 2. 6 minutes? I'll give you 4 and 2 and 5. Diamonds Are Us v. Raffaello and Company. We almost never give that. Do you want time for rebuttal? Yes, please. How much time would you like? 5 and 2 and 5. On the next case, I'm recused. Home Depot versus State of New York. I'll give you 4 and 2 and 4. Zatorski v. Island Transportation.
Appellate 7 and 2, please. Respondents 5.
5 and 2 and 5. People versus Tyrone Howard.
Appellate
5 and 2 and 5. GS 505 Park v. Sherry Layman.
Chris Adams 5.
4 and 2 and 4. Burns versus RP1185 LLC. Who's, go ahead.
RP1185 and at least 2 minutes per Your Honor.
5 and 2, 5 and 2, 3 and 2. Thank you. Martin v. William and Cindy Abrams Trust.
Appellate 7 and 3. Respondents 7.
4 and 2 and 4. People v. Tyshawn Morris. 5 and 2 and 5. Keel v. Kavikio. 5 and 2. Give me a minute. And 5 and 2. Simon v. Lewis, submitted. Funti v. Andrews is submitted. First case on is People versus Andre Harris.
May I
Please.
proceed? Good afternoon, Your Honors. May it please the Court. Nicole G. Uglas, Center for Appellate Litigation, for Mr. Harris. Mr. Harris poses a low risk of sexual reoffense and should be categorized as a Level 1 registrant. His sole sex offense conviction occurred over 2 decades ago in Florida when he was 20 years
Counsel,
old.
weren't the mitigating factors accounted for, and he has an extensive criminal record? Why should we do a downward departure?
In this case, the mitigating factors, the SORA court below found that the statutory nature of the offense was not adequately considered by the RAI and proceeded
down
to
to
the
105.
totality.
Yeah, and then they reduced the number of points asked by the people. The court did. After the hearing, the court gave him 105 points, right?
Based on the, yes, the court scored him 105 points.
Which
based
was a
on
reduction.
The arguments.
I'm sorry to interrupt you, but again, it was a reduction from the RAI, and the people wanted to give him 115 points, so there was already a reduction by the court.
Well, it was a reduction by the court because the people didn't meet their burden of proving by clear and convincing evidence that those points were justified. It wasn't a reduction based on the court's discretion. The court found as a matter of law that there were mitigating circumstances not taken into account by the RAI, and the question before this court is to consider all of the mitigating circumstances and weigh them against any aggravating factors to determine whether a discretionary departure should be granted.
Even if he gets another 15 points, he still would be a Level 2.
That is correct. We also challenge the factor 14 points, but they are not dispositive. That is correct. But it would reduce his score, and that is something that, one, he's entitled to an accurate score, and as well, courts generally take into account where on the risk level range a score is when considering whether to grant a departure. So the points remain relevant even if not dispositive. SORA is intended to consider and reflect someone's risk of sexual reoffense. It's been 20 years since his offense, and yes, he has incurred additional criminal convictions, but nothing sexual in nature. There's no indication in the record that his 20-year-old offense, when he himself was 20, barely out of his teens, and engaged in an otherwise consensual relationship, is indicative of any sexual deviancy or any likelihood that he will sexually reoffend in the future. He's 43 years old now.
Please continue.
And he has engaged in age-appropriate intimate relationships.
So when you talk about 20 years, he's only been out of prison for the last 3 years, right?
Throughout the 20
so it's not like he's been in the community for 20 years, correct?
That is correct.
He's only been out for a couple of years.
He's been in the community for about 3 years. But
Okay, so to say, he has a 20 years of, it's not really quite accurate. He's been back in prison for most of that time.
He has been in prison for a substantial amount of that time. That is correct. But
so he didn't really have an opportunity to commit additional sexual crime for most of that 20 years, right?
I would disagree with that. He could have reoffended sexually.
In prison. Okay, fair enough.
And also in the times that he was out in the community. And courts typically are reviewing and predicting risk forward-looking without any evidence of how someone has comported themselves in the community. And in cases like this, they grant departures.
Thank you, counsel. You have time in rebuttal.
Good afternoon. May it please the court, Faith Petrolio for the people. Defendant was properly adjudicated a level 2 sex offender. Initially, the factor 14 points, he was properly scored points under factor 14.
Counsel, I'm having a little hard time hearing you. Maybe me.
I'm sorry.
Could you put the microphone closer to you?
Yeah, is that better?
Better.
Defendant was properly scored points under factor 14.
Counsel, the mitigation proffered by your adversary is that mitigation that was taken into account by the SORA court and by the guidelines?
Yes, this was all before the SOAR court and was taken into account by the RAI. For example, the lack of violence used in the offense was considered by him not being scored points under factor, I believe it's 1. And that's not to say that, for example, taking the lack of force into account, just because there was no force doesn't mean he's not a risk to the community. So not only were these factors taken into account by the SOAR court and the RAI, there are factors that weigh against them, such as the fact that over the course of 15 months, defendant, as an adult in his 20s, was having a relationship with a 14-year-old girl through
Because
which.
of this, he had been released on parole, hadn't he, or on probation at one point, and he violated probation?
Yes, Your Honor. I believe he was on probation prior to this offense, and he violated that probation. He was on parole and probation for this offense. He violated that. And then in 2020, he did fail to register properly as a sex offender. So there are indications in defendant's record that he is failing to adhere to the terms of the supervision that he is being put under. And so a level 1 adjudication would not be proper in this case.
Thank you, counsel.
Thank you.
Thank you. Mr. Harris is not required to show that he poses no risk to the community. A level 1 reflects a low risk, and that is what his conduct and the record supports, a level 1 adjudication. As to the violation of his probation in connection with the registrable offense, the records from Florida indicate that that was a technical violation. There's nothing to suggest that there was anything sexual in nature about it, or that it's indicative of an increased risk of sexual reoffending, which is what SORA is about predicting, not about predicting general recidivism or general good or bad behavior. Here, while yes, he was 20 years old at the time the offense started, and he engaged in an intimate relationship with a teen who was younger than him, this court and other courts have routinely granted departures where the age disparity was even larger than it was here. And a level 1 adjudication is the right outcome in this case. Thank you.
Thank you. Thank you both. Vitali versus Kaban.
Good afternoon, Your Honors, and may it please the court. My name is Stuart Gold, and I represent petitioner Joseph Vitali. The police commissioner's guilty finding in this case rests on a factual impossibility. The commissioner found that petitioner said a slur while he was speeding to a serious injury accident, but the slur was said at approximately 11:43 a.m., and it was not until 11:51 a.m. that the 911 call reporting the accident occurred. So obviously, petitioner could not have said a slur while he was speeding to a accident that he had not yet been dispatched to. Respondent's only argument regarding the factual impossibility is that the 911 call was that 11:51 a.m. regarding the 911 call was an estimate, but it's clear from the record that there was that was not an estimate. It was actually an exact time that petitioner obtained from the dispatcher.
Counsel, are you pointing to some credibility issues regarding the hearing?
No, I'm saying I'm saying the police commissioner accepted as true that the 911 call occurred at 11:51 a.m. And
what's the standard of review for this court relating to the hearing that
whether
happened?
there's substantial evidence supporting the police commissioner's determination. And the police commissioner determined that petitioner said the slur while he was speeding to an accident. But petitioner was not dispatched to the accident until after the slur was said. So it obviously could not have
what
been
is
him.
it? What is it that you're saying? What time? Where do you get the time that the slur was said?
That was based on the complainant's.
So there's that inconsistency, right? But that was sort of like, this is around the time I think it was. And he took the 1151 from his memo book, not from his memory. He first said he couldn't remember anything about it, right?
Right, but there was
And then he went to his memo book, and apparently the words 1151 were there. So it's not, so the complainant says around this time, and he looks at his memo book because he has no independent recollection and sees a different number, and the hearing officer doesn't find that significant. And you're saying there's something wrong with that?
Well, the police commissioner didn't address the time disparity. And regarding the complainant's statements that the slur was said at approximately 11:43 a.m., this is not like approximately 11 a.m., and that could mean like 10:50 or 11:10.
That's an
They said
8.
11:40.
Your client couldn't remember it at all, except for something that was written down in his memo book, which could have been written down 5 minutes after he got the call. We don't know, and he didn't testify with respect to that. The only number 1151 came when he looked back on his memo book, and he didn't testify to the circumstances surrounding making that entry. And so you're saying that that is fatally inconsistent? That the complainant said around 11:45, and in his book he says 11:51. That's your argument?
So the 11:51 a.m., it's undisputed that that was a repetition of information that petitioner got from the dispatcher. And the police commissioner accepted that. He operated under the assumption that the 911 call was made at 11:51 a.m.
Right, and he said,
Isn't
well,
this really about the substance of what was said, not about the timing? That the credibility determination of the complainants, Wallace and Hoey's credibility determination is what they heard coming from that car.
No, I'm not challenging the credibility determination at this point. I'm just challenging that there was insufficient evidence that it was the petitioner who said the slur. So even disregarding the time disparity of around 10 minutes between when the slur was said and between when petitioner was called to the accident scene, there was also not a prima facie case of guilt established against petitioner. All that evidence showed was that the name caller was a police officer with a male voice who was driving on the Grand Central Parkway near exit 6.
And the license plate.
And a license plate bearing number 59046. Petitioner, he is a male, and he has a male voice, and he's an NYPD officer, but his license plate number was 5940. They don't match, and there was no evidence.
You can return to that on rebuttal, counsel. Thank you.
Your Honors, may it please the court, my name is Amanda Abata and I represent the respondents. This court should affirm because the total evidence supports the commissioner's findings. To start, on the day of the incident, Vitali was on solo patrol in a marked blue and white NYPD sedan. He was assigned to the Queens Highway Patrol, and he was on the Grand Central Parkway in the vicinity of the incident. Further, his license—
Returning to the license plate point, the numbers Ms. Hui wrote down, 59046, and the actual is 5940. Is that significant?
No, Your Honor, as the fact finder held, it's not, it's still essentially, with the total of the evidence, it still sufficiently places Vitali at the scene of the incident. Ms. Hui—
You didn't have an exact license number. Does the record reflect how you zeroed in on the petitioner?
I'm sorry, Your Honor?
You didn't have an exact license plate, right?
Fair enough, Your
You
Honor.
had So how did you zero in on the petitioner?
The CCRB did an investigation, initial investigation, and based on the license plates, the incident, the location, the license plates and the location, they found that it was him. They brought him in also for an initial interview closer to the—
When you brought him in for the initial interview, he couldn't remember much of anything, right?
Yes, Your Honor.
He didn't say, no, I didn't say that, or no, I wasn't there. He said, I don't remember.
Yes, Your Honor. They called him in for the initial interview after determining that he was driving a vehicle whose license plate substantially corresponded to the one identified by Ms. Hoey, and he was in the vicinity of the incident. They called him in for the interview. They asked, and he knew, he was aware about the reason, the allegations that was going to be discussed at the meeting. They asked him if he used the offending slur. He replied, I don't recall. It was years later at the hearing that he then sort of changed position on that to say that he doesn't use that word. So we posit that the license plate, the vicinity, the fact that he was driving in the vicinity places him at the scene, and then after that, you have a determination as to credibility by the fact finder. And what you have are two women essentially telling a consistent story that corresponds to a lot of what Mr. Vitali is saying, and in contrast, you have Mr. Vitali saying that he doesn't remember a lot of things.
And under the substantial basis review, the hearing officer's credibility determinations are virtually unassailable by this court, right?
Yes, Your Honor, exactly, because they're the person who's essentially, they're in the best position to sort of determine those sort of factors. And so you have like these two women making these like credible, consistent statements, and in opposition, you have Mr. Vitali who doesn't remember anything, and the things that he remembers, he contradicts later on. So we would submit that in totality, that there was substantial evidence here to support the fact finder's findings and to support the commissioner's findings.
Thank you, counsel.
I'm not making a credibility challenge. I'm accepting as true what the complainants told CCRB at the interview. What I'm challenging is that there was no prima facie case established against petitioner. There were two other police officers. I mean, we know that there were two other police officers with license plate numbers resembling 59046.
Was there any evidence that those license plate numbers were in that vicinity?
Yes, so they were assisting petitioner on the day of the incident. And
I know, but when this incident is alleged to have happened, is there any evidence in the record to suggest that they were still in the vicinity?
No, but the same thing goes with petitioner. There's no evidence suggesting that petitioner was in the vicinity of where the name calling occurred. The only evidence regarding petitioner regarding the Grand Central Parkway was that he responded to an accident.
On the Grand Central?
Right, but that was he arrived there at 12:25 p.m. And there's no evidence. There's no evidence that he was near the scene of the name calling, which happened at 94th Street.
So he wasn't taking the Grand Central to get to the scene of the accident when this incident occurred, or around that time?
The CCRB, which was the prosecutor in this case, didn't introduce any evidence about where petitioner was before the accident, before he arrived at the accident. So there was nothing placing petitioner at the name of where the slur occurred, more than putting the other two officers who were assisting petitioner on the day in question at the place of the scene. And regarding just one more thing about the factual impossibility, the police commissioner accepted as true that the 911 call reporting the accident occurred at 11:51 a.m. So I'm not making any credibility challenges. I'm accepting the police commissioner's determination, which was the 911 call happened at 11:51 a.m. The slur was said at 11:40.
That's exactly what a credibility determination is. Your client admitted he was on the Grand Central around the time and of when the offensive words were said. The complainant said that, and there were other corroborating information. Those little inconsistencies you're saying are fatal, but that's exactly what credibility determinations are, whether the little inconsistencies make the big propositions correct or not correct, right?
So I'm saying there's an inconsistency within the police commissioner's findings, because the police...
Well, I mean, he also admitted that he used a loudspeaker that day, right?
Right, he's a highway officer. I mean, he said, they asked him, he said he didn't remember because it was 3 years ago, and then they asked him if it was possible, and he's a highway officer. So if, highway officers use loudspeakers on a daily basis, he was just answering if it was possible that he used a loudspeaker on the 3 years prior. And just to answer your question, I'm saying that there's an inconsistency within the police commissioner's finding. The commissioner found that petitioner said the slur while he was on the way to the accident, but he wasn't dispatched to the accident until 10 minutes after the slur was said.
You unpacked that very well in your brief, counsel. Thank you.
Thank you.
Duran versus versus ERY Retail Podium.
Good afternoon, Your Honors. May it please the court. My name is David Cook. I am an attorney with Colin Dykeman. Our office represents defendants appellants in this case. Defendant appellants respectfully request that the court vacate the award of summary judgment. The plaintiffs.
Counsel, you do cite Rodas Garcia in your initial brief, but you don't really discuss it at great length, and it seems to me that case is very similar to this case in that the possibility of two types of testimony being able to be woven together is absolutely present here. He said he had a wobbly ladder and he missed a step. Those things are not inconsistent as far as I can tell.
Well, Your Honor, I believe the case is actually very similar to Albino, which also we cited. I think our Honorable Judge Fryman was involved in. In terms of the factual circumstance themselves, it's
Yeah, but I asked you about Rodas Garcia, which came after Albino. How do you distinguish that?
the records being used in Rodas is different. There is no evidence in Rodas that the medical records were certified, unlike here, which is unlike the instant case where it is certified. It's not. Rodas court needed to consider the hearsay exception with respect to the statements germane to diagnosis and treatment. That's not present here, Your Honor.
Is there any conflicting evidence as to how the accident occurred?
There are two versions of.
Well, okay, one is I fell, and one is I fell because it wobbled.
Well,
Those two don't conflict each other. So is there anything that's conflicting either one of those versions?
It's not one is I fell. It's one is I fell because I missed a step versus I fell because the ladder wobbled. Obviously, to the extent that he missed a step, 240 is not implicated, whereas if the ladder wobbled, then 240 may be implicated, which would show the fact that it is in fact inconsistent.
He missed a step because the ladder wobbled.
I'm sorry, Your Honor?
If he missed a step because the ladder wobbled, where does that leave you?
That's not the way that that the testimonies came out. That it's not explaining what happened. There's two specific, and it's supported by 6 different documentations, and obviously as well as testimony by the superintendent that he missed a step. There's nothing in those instances. There's indication that the ladder.
But there's
wobbled.
also evidence that of the wobble. So what do you do with that evidence?
That's why it should be denied. There's an inconsistency, and it should go to the jury.
I don't
That's not
understand why that's
inconsistent because he
inconsistent.
missed a step because he wobbled. It's very easy to make them to reconcile the two statements.
It's not. If he misses a step and then he falls, that does not implicate 240. If the ladder wobbled and he falls, then 240 may be instigated. So that's the two facts that we have. So ultimately, I understand the court is indicating that he may explain what has occurred. All we know is that the documentary evidence as well as the testimony of the superintendent indicates that that was not the case. The sole reason
It's not that it's, I'm sorry, I don't mean to interrupt you. It's not that it's not the case. It's just that he didn't explain further. So yes, in both situations, he fell because he missed a step. But then when he explains it further, why he missed the step, because the ladder wobbled. That's not inconsistent. It's just one is a smaller statement and one is a bigger statement.
If I could address that quickly, Your Honor. In effect, there's nothing in this different about this case in Albano. That's the same thing there. Then the court at that time could have also stated that could have been an additional explanation. That's not the case. There's an omission. There's a specific omission as to how the accident occurred. To the extent that those two, there's more than one and they're inconsistent, then 240 should be denied.
Thank you,
there
Counsel.
be-
Time rebuttal. Oh, I'm sorry. Please. No, Justice
Well, I was
Sunil Levy
just
had a
gonna-
question.
I was just curious if there were any safety device that could have prevented this, since he did fall from the ladder.
He was two rungs from the bottom, which is about 2 feet, 12 inches each. There's really nothing else that could have been done at the time.
Thank you, Counsel.
May it please the court, my name is Gail Kellner, I'm appearing for respondents. I think that it's fairly clear that Rodas and the case before the court are very similar. There are two occasions where plaintiff established how the accident happened. Within a week after the accident, he provided a form that he signed for workers' compensation stating that the ladder wobbled and caused him to fall. Subsequently, at his deposition, he testified that the ladder wobbled, and as he fell, he missed a step and fell to the ground and saw that there was debris under the ladder, which is what most likely caused the wobbling. As he was working with his crowbar, he said that the ladder was continually wobbling.
What about Andino, though? Because your opponent does cite that case as being an example of slightly inconsistent statements giving rise to an issue of tribal fact.
I think that the procedural posture of albino is quite different. In our case, the plaintiff testified at his deposition that the ladder wobbled, he missed the step, and he fell. In albino, I believe the plaintiff testified that he missed a rung, and then when it came time for summary judgment practice, he submitted an affidavit,
Right, that the scaffold was moving, yeah.
which is a totally, obviously, self-serving affidavits during summary judgment practice are frowned upon, and I believe that was the posture in albino, which is not the case here. I would also point out that the fact that the ladder wobbled, he missed a step, and he fell are totally consistent. Each of the documents upon which the defendants rely in their opposition are not only consistent with that set of facts, but each one is procedurally flawed in its own way. Even if one accepts the diary, the famous diary that was interjected at the 11th hour, that plaintiff missed a step and fell, which
You mean Falzone's logbook?
Falzone, correct, which I think is what he was referring to. Mr. Falzone testified he didn't see the accident, he had no recollection of what occurred. The only recollection he had was what he read in the diary. And it says plaintiff missed a step and fell. So again, that is not inconsistent with the fact that plaintiff both asserted in his workers' comp form and at his deposition that the ladder was wobbling as he was working, continued to wobble as he descended the ladder, and ultimately caused him to miss a step and fell. I think that this is consistent not only with Rodas, but actually with a consistent number of decisions from this court where there's an unwitnessed accident and the plaintiff's testimony or rendition of what occurred are completely consistent and there is nothing inconsistent. I think most recently this court, about 2 weeks ago, came down with D'Angelo versus Legacy Yards Tenant LLC, which is 2025 New York Slip Op 02409, where there were plaintiff's testimony was called into question by 2 accident reports, which this court found were not inconsistent, they were just different details, but the details all fell together and they were all consistent. There is no inconsistent version of the facts in this case to plaintiff's testimony and plaintiff's workers' compensation report, which are the 2 versions that are actually attested by plaintiff. He signed one and he swore to the other, where he stated the ladder wobbled, he missed a step as he fell to the ground, and I think that the court below properly found that summary judgment under 240 was warranted. If this court has no questions.
Thank you very much, Counsel.
Your Honors, I just want to address the concept of what is inconsistent and what would make it inconsistent. One fact allows 240, one does not. To the extent that all the other cases that cited, outside from obviously what was just mentioned, it's related to something else in the record. It doesn't relate to testimony. It doesn't relate to anything else. For example, in ROM, it's affidavits. Same thing with Cuevas, it's affidavits. Sanchez, unsworn accident reports. That's not the case here. Hill, there was depositions first, and then there's obviously it's related to affidavits. That's not the case here. As soon as the accident happens, he provides information to superintendent. He testifies to it later. that he
Let me
has
just ask you,
independent-
did plaintiff ever say himself, I fell solely because I missed a step?
No,
Did
he
he ever
did not,
say
Your
that?
Honor.
No.
He did not.
He did
But I-
not. The only people who are reporting only a misstep are other people, right? Not him. In
It's
his,
party.
his words are in both times that he reported it was because of wobble, right? And the one person denied they even made the statement or signed a statement and said somebody else filled out that report. And the person who wrote he fell from the step says, I didn't see the accident, I don't know what happened. I heard that from somebody else and I put it in my report. So by that is where you are creating an issue of fact?
It's party admission, Your Honor. He told Falzone specifically what occurred, and he wrote it down contemporaneously,
I think
and he
what
testified to that.
Falzone said was that somebody else told him that, and he wrote it down. Right? Or maybe I'm wrong. Let's see.
Should be record 9,
Oh,
930,
okay.
lines 4 through 24, Your Honor.
Counsel, before you sit down,
Yes,
in your
Your Honor.
reply brief, you refer to respondent's brief as so-called respondent's brief. What do you mean by that?
Uh,
Is that sarcasm?
I'm sorry?
Were you trying to be sarcastic?
No, Your Honor.
Because if you were, that would not be well taken by this court.
Understood, Your Honor.
If you have some other explanation, you can tell me what it is.
It's a repeat of what occurred and nothing new with respect to what happened in the underlying motion.
Okay, thank you, counsel. Thank you both. Matter of Diamonds R Us, v. Raffaello.
Good afternoon, Your Honors. May it please the court. What we have here
What you have here first is to get over the fact that you're trying to appeal from a default order. So how are we going to do that? How can we hear your appeal?
well, so that's a procedural issue, but we're dealing with jurisdictional issues, right? The court had no reason to award an affirmation that was never served. It occurred
The
essentially in
jurisdictional
secret in
issue
Israel.
happened, oh, I'm sorry, counsel, let me give you your time, first of all. The jurisdictional issue happened before the Diamond Tribunal, the Bourse, I'm probably mispronouncing that name. That's where the jurisdictional issue happened, not in front of Supreme Court.
Well,
Unless I'm
also,
mistaken. Tell me why I'm wrong.
well, Your Honor, there's a couple of things here. So the burst, there's a totality of jurisdictional problems that was never noticed. No one, my clients never knew about it. So that entire process occurred without any knowledge of my clients. The second jurisdictional issue that exists is
You mean the underlying arbitration?
correct.
Weren't they served with notice of it?
They never were, and there was no proof, nor even an attempt at proof made that they were served with it. It doesn't exist in the record. This second jurisdictional issue is that there's only proof, even within the case in Supreme Court, of service. There's affidavits of service against Nektalov and Raphael, the individual. There's no affidavit of service against the company.
Who are the owners of the company?
Those two people.
Okay.
Yeah, but they never procedurally served the actual entity. And all the memos that you see before you that this is over, only two of which cite to arbitration at the Bourse, only 3 are signed of the 7, and all of them reference Raphael and company in the top right. None of them represents Nektalov or Raphael Aranbayev. So there's an affirmation of basically a secret arbitration that occurred in Israel because no one was notified.
Didn't the arbitration tribunal conduct a hearing on this issue, and didn't the petitioner present evidence allegedly showing that he had served the respondents, and the arbitration tribunal was satisfied with that?
That is not my understanding, Your Honor.
What is your understanding, counsel?
That my clients were never served, there was no attempt at it, and there's certainly nothing supplied in these papers.
There were at least 2 of the 7 memos said, if we have a problem, we're going to go to arbitration in front of the board. So why isn't that some notice? And also, apparently, this is very common in the industry. So how do you get around those things?
I understand that, Your Honor. It's just that very common in the industry doesn't rise to the level of New York and federal law. And
How about
also-
the mentions in the memos? The
I'm
two
sorry?
invoices, the 2 invoices, 2 of the 7 invoices reflect that you would go in front of the board if there was a dispute.
It's the smallest print in the memo, and it's the very last sentence. Yes, Your Honor.
But I still have to go back to how can we hear this if your clients didn't respond to the petition to confirm the arbitration, and that was granted on default. So an order that's granted on default, whether you think it's proper or not, is not appealable. What one does in that situation is go and make a motion to vacate the default, right?
Yes, Your Honor, and that was
And
something
plus,
that we did.
the record reflects that the Raffaello was served by service on the Secretary of State. So I think it's incorrect to say that the corporation was not served. That is in the record. So everybody either was served by, there's a process server's affidavit, and you didn't dispute any of that. You just didn't appear. You didn't, except one person did appear, right? But your clients didn't appear. So the petition was granted on default. Again, going back to the original question, how can we hear an appeal from an order entered on default when that is a non-appealable paper?
Well, Your Honor, what we did try to do is vacate the order. We first filed a notice to vacate under order to show cause on August 30th, 2024.
Court refused to sign that, right?
That is correct, Your Honor. And then, but what they said in the signing is that because the special proceeding is closed, you have to refile an order to show cause to vacate and have it be randomly assigned and deal with it that way. So we did do that. I know it says
So
in
you
the
have a
papers-
remedy. That's what I'm saying. It's
Well, we
not
did-
your remedy list, but you in this appeal are seeking to appeal a non-appealable order.
But we've been cornered, Your Honor, essentially, because we did obey the judge. We obeyed Judge Schumacher. We applied,
could
and
you
then we
at
got a
that
judgment from
point- could you at
Engeron
that
saying,
point
go to the
serve-
first
Let
department.
the
Could you
judge-
at that point
we'll hear
have
you, too.
served a notice of motion and sought to open the default that way? Or could you have come to the appellate division and said, look, the judge declined to sign the order to show cause? He should have. So you are not without possible alternatives to the declination to sign the order to show cause. I mean, on the one hand, with that order to show cause, you are trying to do just what we're asking that should have been done. But when that didn't happen, is the answer to appeal a judgment entered on default, or was the answer to either try to pursue a notice of motion or come to the appellate division then?
Well, we were directed by Judge Engeron to the appellate division. That's in his order. So that's
Finish
why
the
I'm
thought,
here.
counsel. You were starting to talk about something else. So what happened when you did that? It's still, I mean, there's still a pending case?
No, the proceedings remained closed. Both Judge Schumacher, who's the original judge in the proceedings,
He said, "Don't
refused
bring a new
He said,
proceeding."
make a new proceeding. We did that. That landed, randomly assigned as instructed on at the bench of Judge Engeron, who said, I'm not going to do it either. Go back to Schumacher or seek help at the appellate department, first division. Those are 2 judges and 2 judgments that are on the record stating, sending me directly here. So we're cornered to a certain extent. We did
I don't
everything
think
that
you're
we could.
cornered because the order that denies your motion to vacate on a ground that you can't vacate the order because the petition was disposed of is clearly an appealable order. But that's not the order you're here on. You're here on the order granting on default the original petition to confirm the arbitration. You have plenty of remedies. You just don't have the remedy to appeal a non-appealable order.
You can cogitate on that, counsel. You're on rebuttal.
Good afternoon. If it pleases the court, I'm Mark Altschul for the petitioner respondent. I don't know that I could really add anything more.
Well, I want you to talk about that. Are they in some kind of procedural cul-de-sac where they can't be heard?
I I believe that, yes, they may have had an opportunity to appeal the denial of the order to show cause. But
Not the denial, the refusal to
I'm sorry, a
Refusal to
refusal to sign.
But here they were told by one Supreme Court judge, go bring another petition, and the next one says, no, I'm not going to hear this.
Yeah, what specifically did Judge Ngoran say?
I'm sorry.
What did Judge Ngoran say that no?
I'm going to say that although I saw those documents previously, I did not prepare for them today, so I
Right.
don't know what
Right.
Judge Engeron said specifically.
Okay.
So I couldn't address that.
Okay.
If there's no other questions, I'll just sit down then. Thank you for your time.
Okay, thank you.
May, Your Honors, I can give you the exact verbiage of both orders. Judge Engeron, which was our second up to bat, correct? He said, decline to sign. Any relief must come from Judge Schumacher, who sent us out, or the First Department. Signed, Honorable Arthur F. Engeron.
That's in NISIS?
That is.
Okay, thank you. Anything else you want to say?
No, I think that covers it. We just, we got kicked around a little bit and ended up here, and I may have tried to appeal the wrong judgment, but at the same time, this is, on a jurisdictional level, this is an arbitration award that existed completely. Had the whole process and the decision itself in Israel happened in secret. There's no evidence of any kind of any service ever on anyone for that. No notice of any kind.
All right, thank you very much, Counsel. Thank you both. The next case, I'm recused.
Go ahead.
Good afternoon. My name is Miriam Skolnick, firm of Hertzfeld and Rubin, and we represent the State Insurance Fund. I think that what we're dealing here is pretty basic contract law, which is there can't be a breach of contract action, can't accrue until.
What if the Second Circuit had affirmed the district court on the grounds of common law indemnification? What would your position be then?
Then we would be liable. I mean, then they would be, that would be an enforceable judgment in the state of New York. It would be, we would be collaterally
And they would be
estopped.
entitled to interest from the date of the district court judgment.
Yes, but there wouldn't have been a breach of contract action. It would have been federal, and more than likely, we would have paid it. But here, the Second Circuit, knowing full well, because there was full disclosure, that there would be no insurance coverage if they didn't find grave injury, and if they didn't affirm common law. But they nevertheless.
They didn't rule on the common law, did they?
Pardon?
They didn't rule on the common law.
Well, but they knew grave injury was a requirement for common law.
But
I mean, how can you say that? How do you know what the Second Circuit is
because
thinking?
I argued
You
the
can
case.
we can only look at what the Second Circuit wrote. And I appreciate that you think you knew what the Second Circuit judges were saying. I'm sure everybody in the audience thinks they know that what we're thinking, but all we can go on is what they wrote. And they declined to address that issue, right? That's all they said.
Yes, okay.
All
And
right, so let me go back to something. And we're talking about basic contract law, right?
Right.
Basic contract law is the contract is breached at the earliest possible time that the claim arose. When is the earliest possible time that this claim arose?
according to this court's decision in 2022, in this very case, it arose when there was a finding of grave injury, because there was no coverage under the policy until there was a finding of grave injury.
Why doesn't it arise when the incident of grave injury occurred?
That's never been, because there has to be proof. Workers' compensation law,
But every breach of contract has to be proved. That would literally mean that you could never get a judgment for a breach of contract until the terms of the contract fulfillment were proved.
no, excuse, the workers' compensation law doesn't address the breach of contract claim. Workers' compensation law addresses whether or not Home Depot could state a claim against Bryant, our originally insured, for common law indemnification.
And
Sorry, go ahead.
and once there's a grave injury, the
Finding.
once there's a grave injury, then the state insurance has the obligation to pay. The finding only comes when the state insurance fund disputes it.
So it's once a grave injury has been sustained.
Pardon, no, the statute says, and I have it here in front of me, it's only when until such third person proves through competent medical evidence that such employee has sustained a grave injury. It doesn't go, it's no different than any other
So
insurance policy.
when is a grave injury sustained? When it's found that it's sustained, or when it actually happens?
It's for purposes of being able to obtain a judgment of common law indemnification when it's actually proven, not when it's sustained. There's not one case that has retroactively found an obligation to provide coverage. It's the same in any kind of an indemnification, insurance indemnification provision. Someone is sued, okay? The insurance company says, we're reserving rights on indemnification, we're going to defend you.
And then we give interest from the date of the demand that was wrongfully refused. That is how we do it all the time, right?
Going back to before there was a finding of liability?
When the demand was wrongfully made, that's when the interest starts to accrue.
demand-
That under general insurance policy.
Even an indemnification claim? I haven't seen a case that
Yes.
says that.
You have time in
And they
response.
haven't cited
You have
one.
time in response, so
Okay, can I just make one point, though?
you'll have rebuttal.
Okay.
May it please the court, Ronan Doherty for Home Depot. There is just one issue left in this odyssey of a case, and that is when the claim for breach of contract, breach of the insurance policy accrued. As the court has already pointed out, that is long before the contract plaintiff wins a verdict. The claim exists from, in the words of 5001, at the earliest possible moment that it's attainable. And when you have a contract that hasn't been paid and there is no deadline in the contract, the New York cases say it goes from the date that the plaintiff makes the demand for payment. That's the bright line rule. That is what the Court of Claims did here, following the precedent to the letter exactly. And that is all the court needed to decide to affirm.
So in the litigation in federal court, was it about the interest or was it about not having to pay at all?
The litigation in federal court was the original underlying case.
Right.
And that was about...
But we got to the part of it that's in front of us now.
So the part about the decision for interest there was part of the judgment. There were two judgments entered in that case, one against Home Depot as the first party defendant, and then one for Home Depot. Both of those allowed for the recovery of post-judgment interest. So that's an element of this appeal, although the fund's opening brief never really addresses post-judgment interest. That we think has been waived, but that's part of the judgment that was entered against the insured, and so has been part of the claim here for coverage all along. And just under the plain text and the face of the Rivera Court's judgment, post-judgment interest was awarded, and under the policy, it's part of what the insurance policy covers.
What about our previous decision in this case that said that the state insurance fund policy would be determined after the underlying federal action determined grave injury?
So the last time we were here, we were talking about cross motions for summary judgment. Home Depot's argument then was that the record, without having to get into grave injury again and medical evidence again, was sufficient to hold the fund liable. This court, and affirmed the trial court below, said no, collateral estoppel does not bind the fund. So while the insured Bryans might still be liable on that theory, the fund can defend and can insist that you prove it over again. We did that, and that decision's not up again on appeal. But all the court decided in 2022 was whether or not the record that was before the court then was sufficient for Home Depot to win. There was nothing in that case talking about whether or not Home Depot's claim had accrued. If Home Depot didn't have a claim on the day we were here last time, surely the court would have said so. Instead, the snippet of that decision that the fund continues to cite comes in a sentence that says summary judgment was appropriately denied. That's all that was decided before. And so again, under plain New York precedent and the black letter law, interest in this case began running on the date of Home Depot's demand in April 2020. I'll cede my time. Thank you.
If I may, the demand letter that was sent here by Home Depot, which is at page 141 of the record, specifically says that the reason that they can make this demand is because the condition precedent for the fund's obligation to indemnify Bryant, meaning a finding of grave injury, has been satisfied. That was not the case in 2020.
Or how about just grave injury? Not a finding of grave injury. They're saying there was a grave injury.
But that
And that's
wasn't,
why they're
because
requesting.
The statute is absolutely clear. I would ask the court to please look at the statute, and there are cases.
I don't think I don't understand when you say that the statute is clear. It says nothing about accrual of a claim for breach of the contract.
It's not the it's the issue of how you prove of how you establish that there was a grave injury.
But that has nothing to do with when the claim accrues on a breach. That's a different issue. That's what you keep saying. That would literally say that you could never have a breach, you could never have interest on a breach of contract claim until a court found the breach of contract. That's just not the law.
But that's not our position. Our position is that there could be no breach of the contract until there was a finding that there was an obligation to cover. And here there was no obligation to cover because the condition precedent of our obligation to cover is a finding of grave injury. That's a requirement of the workers' compensation law. It's a requirement of our policy. It's like you would come in and say, I'm entitled to coverage on a claim for loss of property, but it turns out that I embezzled the property, right? That's the defense.
Or what it could
Until
be,
you prove
or
that it's
what it could
covered
be,
by
the
the policy, there's no coverage. There's no obligation to comply with the demand.
And you're saying that if an insurance company denies a claim for 10 years, and then it goes to, and it's a breach of contract claim, 10 years later, the finding is that the insurance company breached the contract, and then you can't get interest from that time?
Schiavone did not reach the issue of interest, but it reached the issue of when a breach of contract claim accrued. And in Schiavone, it was exactly this case. You had a breach of contract claim, which was not covered. You had a personal common law indemnification claim that was covered, a contractual indemnification. The case was settled, and it appeared that it was done on contractual indemnification. It appeared that the other claim had been withdrawn. The insurance company denied coverage. Plaintiff came in and said, pay me. You owe the obligation. And the Court of Appeals said no, because there's been no proof that the reason you settled the case was on the common law indemnification, which is covered, versus the contractual indemnification, which is not. And now we have a new trial. Now, under that circumstance, till that's proven, there was no obligation to provide coverage. That's what the Court of Appeals said in Schiavone. So here, what this court said in 2022 is that there's no coverage until there is evidence, proof, not evidence, proof of a grave injury. And here, the grave injury that they proved in the Court of Claims was not the same injury that they tried to prove in the federal court. In federal court, they came in and it was a head injury. And then they abandoned that, turned to loss of use of the hand, came in with brand new evidence from a brand new doctor who was able to examine the plaintiff in 2021 and somehow determine, without whatever the reasoning was, but the Court of Claims accepted that as evidence, but that doesn't prove that there was a grave injury at the time that they made their demand, which is at the time, which is when the breach of contract would have had to occur, but we had no obligation to cover at that point.
Thank you both.
Thank you.
Zatorski versus Island.
May it please the court. Good afternoon, Your Honors. Jamie Felson from Millman Labuda Law Group for the appellant. The test here is whether an employee is likely to be called on to perform interstate travel, regardless of how often they actually do perform interstate travel. And that's from the Fox case.
Would you say that the test is very fact-specific?
The test is fact-specific. It looks at various factors, including what notification an employee was given about their expectation of going interstate. That's one factor. And in this case,
How do we decide all of those factors on a pre-answer motion to dismiss?
there were 26 exhibits provided, all supporting the fact that this individual not only expected to go interstate, but actually went interstate 18 times during his employment. There's cases we cited.
The times that he went interstate were out of over the 10-year period that he was employed. Was it within the last couple of years?
So he was a long-term employment. He was on and off because of workers' compensation. But in the 6 years New York labor law statutory period, he worked, I believe, about 4.5 out of 6 years. And there was, I think, the last quarter of 2018, he did 15 runs. The following quarter, in January, he did a few, I think 1 or 2 runs. And he also performed 3 runs prior to the statutory period, 1 in each of the prior years before the statutory period.
Isn't this over a course of 10 years?
This is over the course of about 10 years, but in the statutory period, there were 15 runs. But I want to point out that
you need Fioretti's affidavit in order to make your case, don't you?
Mr. Fioretti's affidavit is needed in order to get into evidence.
Pull this all together. Is that what's normally considered documentary evidence for a 3211A1 motion?
Yes, I mean, the plaintiff has not argued in response to various documents. For instance, we included a collective bargaining agreement. That's documentary evidence.
About the spreadsheet, what do we know about that spreadsheet that's attached to Mr. Fioretti's affidavit?
The spreadsheet is a summary of...
I know what it is, but who prepared it? Was it prepared in anticipation of litigation, which would mean that it's not something we can consider?
Mr. Fioretti...
And also, how do we know, what went into it and who made it?
Mr. Fioretti prepared it. It's basically a summary of all the bills of lading. If we included all the bills of lading, we probably would have close to 1 million documents. But let's just put that aside for a second. We cited numerous cases, Chacon, Chow, Garza, Gonzalez, and the list goes on, where the plaintiffs in those cases performed significantly less interstate runs than the plaintiff here. For instance, in Cho...
All those cases are summary judgment motions, correct?
I'm sorry,
All those cases are summary judgment motions, correct?
they're summary
Are
judgment
there
motions.
any that are pre-answer motion to dismiss grants?
Your Honor, I'm not sure that...
I
other
am, so
jurisdic-
let me just ask you, are any of them granting a motion on a pre-answer motion to dismiss?
I don't
Without
believe so.
discovery,
But
no.
Your Honor, one
None.
point critical to that is we're talking about a federal statute that the New York labor law applies. So we're looking at cases throughout the country, and many jurisdictions, unlike New York, don't allow a motion to dismiss under 3211A1. So, my client shouldn't be faulted just because other jurisdictions don't allow these motions. These motions are allowed. We submitted significant documentary evidence. The plaintiff was notified through wage notices that are required by the New York labor law that he could go interstate. The plaintiff was notified.
Yeah, but that's saying that there's a possibility. What actually happened is something to be determined
The test
by the
is,
facts,
the
right?
The test is whether he's likely to perform interstate travel. And he was notified in various ways. The company complied with the Department of Transportation regulations, which only apply to interstate haulers. And not only that, but he actually did, in fact, perform interstate runs. In the Cho case, the Department of Labor did an investigation over a 17-month period. Not one employee went interstate. The court concluded that merely because the company solicited interstate business and obtained a contract for interstate business, that the company was going to perform interstate runs, and the plaintiffs had a reasonable expectation of performing some of those runs.
But you look at like the Supreme Court case of Morris v. McComb, and there was so much more evidence about how people were picked, because you can't make a blanket rule that anyone who is just generally told that they may go interstate is not subject to the federal law and not subject to labor law. That's clear. So what have you put in, and what if the plaintiff had the opportunity to test none of your evidence and to ask you for additional evidence to decide how people were decided. Because what the plaintiff says is that there were certain people who were doing almost all the runs. I wasn't one of them. And it's an individual, not a blanket decision, right?
Your Honor, but even with discovery in these other cases and depositions, there's like 10 cases we cited where the court performed no analysis whatsoever about the manner in which the company decided how to assign interstate runs. And that was after discovery where that question could have been asked. None of these decisions discussed that at all. That wasn't a fact in the court's decisions.
Thank you, counsel. You have time, rebuttal.
Thank you.
May it please the court, Jack Newhouse for plaintiff respondent. So the standard for the Motor Carrier Act exemption is that the employer has to demonstrate that a natural, integral, and inseparable part of the employee's duties such that any employee is likely to be called upon to travel in interstate commerce. The issue here is really that where there is a situation where employees aren't traveling frequently across state lines. They're only traveling across state lines in a limited capacity. And in those types of cases, it makes a lot of sense that the standard, which has been applied by a lot of these Eastern District of New York cases and Southern District of New York cases, that there needs to be indiscriminate assignment of the actual interstate trips. Because if it's specifically designated to a certain group, then the employee who's only crossing state lines a limited number of times.
But the ITC drivers, they didn't pick their own routes, right? Isn't that a sign of indiscriminate assignments?
No. I think indiscriminate assignment would suggest that it's randomly distributed amongst the drivers. So this actually is highlighted in certain of the chauffeur cases. So you might have a chauffeur picking individuals up from the airport. They might be doing intrastate trips or interstate trips, but it's random. It's dependent on what the passenger is asking from the driver in cases like that. And so you need this, it's fatal to the defendant's argument that they haven't established this indiscriminate assignment of interstate trips, because how can an employee...
Does it have to actually be indiscriminate, or does it have to be that they take the position that they can send, and in fact, the union contract says you can be sent anywhere, anytime, any place. Is that enough?
No, it's not enough. I mean, any employer can identify a policy, just like Judge, Your Honor mentioned earlier. Any employer can identify a policy where there is an expectation of interstate travel, but that doesn't necessarily comport with the practice. And what actually the dissent in Morris, which is very telling, was afraid that employers are going to start creating a situation where all they have to do is say, okay, well, you might go in interstate commerce, have a little bit of interstate commerce themselves, assign two drivers to drive across state lines, and then everyone in their workforce is exempt from overtime, which was a major fear, and is clearly not the law.
What about that plaintiff did do interstate commerce?
I'm sorry.
What about that there were interstate trips?
Yeah,
There were 14 or 15 interstate trips.
Sure. I would point your honors to two cases which I think are very telling. One of them is the Williams versus Tri-State Biodiesel case. That decision is comprehensive in terms of the analysis of this entire body of law. And in that case, there were interstate trips, but they were limited interstate trips. And the specific dispute that the court held in order to deny the defendant's summary judgment in that case, the specific dispute was because the plaintiff asserted that there were specific drivers that were designated to the interstate trips, so that driver didn't reasonably expect to be called upon to drive in interstate commerce. There's two...
So what would the defendant have to show in order to establish their exemption from the Motor Carrier Act?
What would they have? I mean, they would have to show that individuals were that an integral part of a driver's duties is that they could be called upon to drive across state lines. But it has to be
showed that by the union contract.
No. Just because the union contract to me is the same exact thing as because again it goes to the indiscriminate. How can an employee who drives across state lines in a 3-month period basically 15 times, and that's basically it over the course of years. There might have been one or two others within the statutory period. How can that employee reasonably expect to be called upon to cross state lines when there are specifically designated individuals to do the interstate
His union
trips?
contract says he can.
Exactly, and that goes back to the issue of you can't just identify in a handbook that you might get called to cross state lines, and then that is sufficient in and of itself. Remember that, like as was said, this is a pre-answer motion to dismiss. There's more discovery that needs to occur, and if there were, let's just say there were 700,000 additional trips, the 5,761 interstate trips isn't going to look, very convincing in terms of somebody's likelihood.
It's like a 4-month period that the courts have been looking at.
Yeah, there's the format that I know that
Counsel, what about the affidavit submitted here? What import should we give to that?
So there's a lot of documents that were submitted that are documentary evidence, but in terms of the assignments and the policies for assignments, that all comes from paragraphs 28 and 29 of the Fioretti affidavit, and that's just not documentary evidence. That's just his attestations. Even there's nothing in the collective bargaining agreement that discusses indiscriminate assignments. There's two really very quick points, if that's okay, that I just like to make that were raised in the reply.
30 seconds, counsel.
What?
30 seconds.
Thank you very much. I appreciate that. One is the Encino case. Encino is the Supreme Court case which held that exemptions shouldn't be narrowly construed. This exemption and the Quartararo case addresses this. This exemption, the Motor Carrier Act exemption, was not narrowly construed. And the last is the defendants stated that 5,761 trips that were in the spreadsheet were interstate trips. Because the New York fleet drove from New York to Connecticut and then distributed oil within Connecticut, that's not an interstate trip. That's an intrastate trip. In order to qualify for the Motor Carrier Act, you have to...
Thank you, counsel. I think you make that point in your brief.
Okay. Yep.
Thank you.
Okay.
Just a few final quick points, Your Honors. I just want to point out the Brennan case. In that case, the employees were members of a union like here, and those employees actually chose their routes based on seniority, and there was a substantial unequal distribution of routes, and the court still there held they're all exempt.
That's my whole point. All we have is your guys' statement without giving the plaintiff any opportunity to actually look at the documents that would substantiate that or not, or take a deposition. It may be that your client is correct, but it may be that the documents absolutely tell a different story. How can we know on a pre-answer motion to dismiss?
Your Honor, but from the Brennan case, it doesn't matter how many routes are assigned. The fact that they have a reasonable expectation of a route being assigned is sufficient for all the employees to be exempt.
I think the Supreme Court says it does matter.
Your Honor, that case, the Supreme Court case was from 1947. There's dozens of cases
Hasn't
that
been
have been decided
overruled
since then that don't talk about the assignment of routes. So Garza and Gonzalez, in that case, the employees signed a contract with the company saying that they could go interstate. The court relied just exclusively on that document and said that they had a reasonable expectation based on signing that. Here, similarly, the employees, Mr. Zatorski was given a memo at the beginning of his employment that said that you're going to be driving through the Holland Tunnel, the George Washington Bridge, which obviously goes interstate. So that's one of the 26 exhibits that we included in the affidavit. One final point on the 4-month rule. That is not law. The plaintiff and the cases cited by them, it's a notice of interpretation from the federal regulations. And courts have said that it's not law. It has no binding authority. And even those cases that have followed the 4-month rule, critically here, they don't look at the number of routes that the plaintiff performs. They look at the number of routes that the employer performs. And here, over the 6-year period, there were close to 6,000 routes, an average of 3 per day. So the 4-month rule doesn't help the plaintiff's cause here. Thank you.
Thank you, counsel. Thank you both. People versus Tyrone Howard. Please.
May it please the court, Svetlana Kornfein for appellant Tyrone Howard. The evidence, when viewed in the light most favorable to the defendant, Mr. Howard, supports a finding that Mr. Howard believed it was necessary to use deadly physical force to defend himself from an imminent and unlawful threat to his life. And the jury could also find that his belief and his response were
What evidence
reasonable.
are you relying on to establish that it was reasonable?
Well, it was reasonable because given the circumstances of the case, and I know that you're familiar with the facts in that Mr. Howard was fleeing, being shot at by 3 armed men.
What I'm trying to direct your attention
Yes.
to is what exactly are you relying on from the testimony that it was reasonable at the time when he fired on law enforcement, that he was justified in doing so?
Right. Well, there are 2 issues that were tribal facts that the jury should have been able to determine. The first is whether Officer Howard had his gun drawn
But
at
where
the
do you
time.
have evidence of that? Officer Wallace testified that he didn't.
Yes, well, there was actually physical evidence that Officer Wallace's gun had been drawn at the time that he was shot.
What physical
and-
evidence? The fact that it was found close to his body?
Yes, and in fact, the prosecutor below conceded that, and respondent is conceding that on appeal. The issue
No, I don't
is,
think that's right. I think
Yes.
it could have, what they're conceding was at some point,
It could
the
have
gun
fallen
came
out.
well, but there was only a couple of.
There's no testimony, 0, that the officer had the gun in his hand when the defendant shot him. None, nothing.
Well, but
In fact, there's contrary evidence from Officer Wallace.
Officer Wallace formed the memory of this event in shock and trauma. His memory was
Right, but
imperfect.
even if that's the
been-
case, right, what else do we have in the record to sustain your argument? What other facts can we point to that came out during the course of the trial that would sustain given a justification charge here?
The crime scene photo showing the gun feet away from Officer Holder's body down at the end of the ramp by the bicycle, and the prosecutor below twice before the trial and during summation saying, yes, he drew his gun, but their theory is he drew his gun after he saw Mr. Howard's gun. The jury could also find that Mr. Howard drew his gun upon seeing Officer Holder's drawn gun because it's more reasonable.
What do you have in the record to support that is a reasonable view of the evidence, that could be a reasonable view of the evidence?
Well, if Officer Holder had his gun drawn and Mr. Howard saw the drawn gun,
But none of that is evidence in the record.
Yes, it
That
is
is
record.
literally your own supposition.
It's not
All
my
that we have in the record is after he was shot, the gun is out of his holster, right? That's the only thing. And the testimony is that he didn't have his gun drawn. So you're saying, based solely on the fact that his gun is not in his holster when he falls to the floor or the ground after being shot, that sole fact gives a reasonable inference of justification.
Well, the reasonable
I'm
inference
just
is that...
it's a yes or no. Is that your argument?
No, the reasonable inference is that his gun had been drawn, and then when he was shot, it fell forward.
What
onto
about the other
ramp.
testimony,
That's the evidence.
counsel? What about the other testimony that we have, and the only testimony that we have regarding
Is Officer Wallace.
Oh, you're gonna ask my questions for me?
Sorry.
Okay, thank you. That the officers had all of the indicia of being officers when they approached your client.
Yes, and so that's the second tribal fact of whether the knowing element.
It's
whether
only
was-
triable if we have evidence to the contrary.
Right,
If we
well,
have
the
a
evidence-
reasonable view of the
Yes.
evidence that suggests something different.
Viewed in the light most favorable to Mr. Howard, the area at the base of the ramp was dark. It was nighttime, end of October.
But
There
that's
was
not what the evidence in the record supports.
Yes, it is.
The evidence supports that it was well lit.
No, it wasn't well lit.
Okay, well,
No.
tell me where. Like, tell me what in the record. What testimony from who?
Well, the one witness
who could have testified about the lighting conditions was Officer Wallace. He was never asked. We have the crime scene lab and the prosecutors and a colloquy where the crime scene lab described the area as poorly lit. We have evidence from the defense and also from the prosecution that none of the lighting on the promenade was working, that there was no lighting
All
on
of
the
this,
footbridge
Matt,
at
is
all.
only if you accept the proposition that contrary to Officer Wallace's testimony, Officer Holder had his gun drawn before he was shot.
Well, that's right, but it also matters. I mean, it's given Officer Wallace's testimony, and it happened instantaneously, okay? Mr. Howard rides up to the base of the ramp. He dismounts when he sees the officers. Wallace testifies. He starts to come up the ramp. He was on a bicycle, so when he saw us, he got off the bicycle. You also have to remember, they were expecting to see an armed man on the suspect in a dark pants, light pants, dark, exactly matching Mr. Howard. They had the radio communications. They were expecting to see
Thank you,
exactly
Counsel. You have
Mr.
time on
Howard.
rebuttal. Thank you.
Good afternoon, Your Honors. Dana Poole for the people. What the evidence that we have here is that Officer Wallace testified that neither he nor Officer Holder had their guns drawn as they approached defendant initially.
Counsel, let me ask you this. Did the prosecutor concede that the officer who was shot was holding his gun, preparing to shoot? That's, I mean, what we've heard, that there
Right.
was testimony from the argument is that the prosecutor conceded that.
No, what the prosecutor was arguing was the fact that that Officer Holder would have gone for his gun when he saw defendant reach for and pull out his gun.
How do you deal with the fact that the gun is out of Officer Holder's holster?
The most reasonable explanation, given the testimony that he did not have it drawn or pointed at the defendant as they approached, is that when he saw defendant reaching for and drawing his gun, he unholstered his gun, was shot, and it fell next to him as he
Fell
fell.
out by itself after he was shot.
It fell from his hand. I believe the understanding was that the gun would not have unholstered by itself, but there was no evidence that Officer Holder had been the first to unholster his gun. And we know that Officer Wallace had not unholstered his gun because he specifically testified not only had they not done that, but after defendant shot and his partner fell, Officer Wallace was reaching for his gun at the same time he was reaching for his radio. So they were not approaching with their guns drawn.
And in order to, Brown says, to get that justification, he'd have to have his gun in a position where he was readily able to aim and fire it imminently. Is there any testimony, any documents, anything in the record that would show, other than the fact that the gun is by his side, that he had his gun in his hand and was ready to shoot it imminently?
Absolutely none, Your
The
Honor.
only evidence in the record was he didn't.
That is correct.
And they were identified as police officers in the sense that they had their badges out, they had bulletproof vests, they had orange armbands, they had radios the size of bricks when they were approaching.
Batons, flashlights, they had the whole utility belt.
Is there any evidence in the record that the defendant was able to see that?
Well, the defendant didn't testify one way or the other about what he could see, but defendant is asking this court to speculate that he could see a gun, but he couldn't see a shield. And we know that Officer Wallace could see defendant well enough to identify his face as somebody he'd seen a year before.
What evidence is in the record about the lighting conditions at the time and at the location of this incident?
So several of the responding officers and detectives testified that it was pretty well lit. From there was signage that was lit. There was not lighting on the overpass itself. That is correct.
And we're talking about the entranceway into Randall's Island, right?
This is over the
FDR?
Yes, thank you, Your Honor. at 120th Street. So yes, there are plenty of cars. We have testimony that it was slow moving, so there would have been cars backed up. So while it may not have been daylight, it was and we do know that Officer Wallace could see the defendant's face. So certainly defendant could see those shields around their necks.
At the end, to get to the justification charge, we would have to conclude that at a minimum, Officer Wallace was mistaken about the fact that either he or Officer Holder had their guns drawn. And seeking a justification charge, I don't think it's the court's role to make that credibility determination that he was mistaken, or perhaps even worse than that, just not being truthful. That wouldn't be the sort of determination that we would make.
That's correct, because the evidence has to be non-speculative, and in this
We'd
case,
have to find something that would say that there's a reasonable view of the evidence in the light most favorable to the defendant, that justification is supported by some evidentiary facts, right?
That's correct, and that the defendant actually believed and reasonably believed that Officer Holder was an imminent threat, meaning that he had his gun raised and pointed, and that he was not identifiable as an officer, and therefore that his imminent threat was unlawful. Unless the court has any other questions, I'll rely on my brief and ask you to affirm. Thank you.
Justice Friedman is correct. It's not up for this court to speculate or to judge credibility, but there was enough here to send it to the jury and let them decide whether Officer Holder's gun was drawn, because there was evidence that it was not next to him, it was at the end of the ramp next to the bicycle, so it went forward. So there was reasonable view of the evidence, seen in the light most favorable of Mr. Howard, that he in fact believed that there was an imminent threat to his life. And I neglected to say at the beginning that neither officer, as they came down the ramp in this split-second occurrence, Officer Wallace said, hey, neither officer identified themselves as police. It was dark. We know that Officer Wallace recognized Mr. Howard. We don't know if Mr. Howard recognized
But we do have
the two
the
officers.
testimony from everyone else who said it was well lit. And
those are
we have nothing.
responders.
Yes, it was dark because it was night, but we have no testimony or any evidence whatsoever that the defendant could not see the officers and their shields and their vests. And the only evidence we have was from the officer who responded, who's still alive, who said, I could see him and I could identify him, and the other officers in the area who said, well lit, and the circumstances of the night, which was traffic with headlights on and everything else. So there's no evidence in the record other than it was night to indicate that the defendant couldn't see them.
No, the record is replete with evidence that there was no lighting, that the crime scene lab report had no lighting. The one witness who could have testified about the lighting, Officer Wallace, was not asked about it. So
was he asked by your client's attorney?
It's not our job. It's the people's burden of proof below. The responders came after the fact with their police cars all lit up. It was a completely different circumstance. So in the record, there's ample proof that it was dark at the base of the ramp, that it was not well lit. That's the antithesis of what happened. And so based on that, we're asking the court to reverse and send it back for a new trial at which the jury can decide at what point Officer Holder had drawn his gun and whether in fact Mr. Howard acted in belief that his life was in imminent danger.
Thank you, counsel. Thank you both. GS 505 Park v. Sherry Layman.
Good afternoon, Your Honors. James Schwartz for Plaintiff, Appellant, Landlord, 505 Park Avenue. This is a case in which the landlord is seeking to enforce a commercial guarantee of a lease. The commercial guarantee that was signed.
And then the modifications of the lease. So you say so your argument is the guarantor should be let out. But the guarantee is so unequivocal that the fact that there are changes made to the lease do not diminish the guarantee.
I concur in that sentiment, Your Honor. It does not diminish the guarantee. The case was dismissed below on a 3211 motion. There are cases from this court, most particularly the American Bank versus Coppola case decided in 1982, which have held that this type of guarantee does not.
My question will really be for your adversary.
If there are no questions that the court has for me, I don't want to take up the court. I don't want to take up the court's.
Well, we don't want to stop you either. If there's anything you want to get out,
excuse me.
We don't want to curtail your argument either.
Well, that's fair. That's fair enough. So first of all, the guarantee is extraordinarily broad, but in the 1% chance that I am wrong or that the law is not what I say it is, then you have the issue of this modification. And looking at the substance of the modification, the question is the modification a so-called material modification or is it a mere lenience? This is not the central point in my argument. The court should never get to this issue. But if that is the case, then you have a factual issue, which again is not to be decided on a motion to dismiss, but rather on summary judgment or other proceedings in the court below. But the main point, yes, Your Honor, I'm sorry.
No.
Oh, I thought you were ready. I thought you were ready to ask a question. The main point is that given the breadth of the guarantee, it has been virtually universally held that this type of guarantee is one in which the modification of the underlying lease does not let the guarantor out of liability. Thank you, Your Honors.
Thank you, Counsel.
We please the court, Jesse Schneider on behalf of respondent Chris Adams.
So now let me ask you, how do you get out of this guarantee, which is so unequivocal about the fact that changes in the lease will not affect the guarantee?
Well, Your Honor, I'm not asking the court to ignore that language, and neither did the lower court. The lower court found, despite that language, that Chris Adams was to be discharged, and I'll tell you why. Because the general rule is that a modification of a guarantor's obligation without the guarantor's consent discharges the guarantor under White Rose. Now, this rule is especially true and strictly applied when the guarantor is a private individual rather than a company, and it's also especially true when dealing with a good guy guarantee. It's very important to understand that this was a good guy guarantee that he signed 18 years ago. Why is that important? A good guy guarantee assumes that the guarantor has control over the tenant. And when the guarantor has control over the tenant, it's very reasonable to say that you've pre-waived any right to object to any modification of the lease. But landlord, not once, not twice, but 3 times modified this lease years after Chris Adams had left the company, and during a time when this company was under federal investigation and allegations of fraud and the like.
Did your client take any steps to terminate his obligation under the guarantee after he left the company?
Couldn't. It was years ago. He had given his shares back for cents on the dollar. They were not talking to him anymore. That did not end very well. But this court was very clear, notwithstanding the language that everyone's pointing to, when you increase the risk that you're going to have to look to the guarantor to begin with, okay, and by extending and forbearing on their right to terminate this lease 3 different times.
So, counsel, you're saying that even though the guarantee indicates that a modification of the lease will not extinguish the guarantor's obligations, the fact that there's a modification extinguishes the guarantor's obligation?
No, the fact that there were 3 separate modifications, all of which they forbore on their right to terminate the lease, thereby increasing every time the amount of liability that would hold to the guarantor at a time when the tenant had no business being in business.
Is it the repetition, counsel? Is it the repetition? Because you also, you do cite Spring Prince versus Tahari. You cite that in your own brief. But there it was found that the subsequent agreements between the tenant and the landlord did not obviate the guarantee. So is it that there were multiple changes to the rent due?
No, the key difference here is that it was a good guy guarantee. He no longer was with the company and had no control over the tenant and the right to end
but the landlord
liability.
you cannot take away the landlord's right. Your client made the choice to do that, and without the landlord's consent, your client just can't walk away from the guarantee. That is for sure.
So they
And your remedy is if you're upset with the tenant, your remedy is the cross claim against the tenant. The landlord has nothing to do with your business with the tenant. The landlord can't control whether you leave or not leave. The only thing the landlord has is your obligation, which you've said straight up will not be affected by modification. So your choice is to either go to the landlord and say, I want to get out of this guarantee, or sue the tenant, cross claim against the tenant. That the landlord doesn't get punished because of your fight with the tenant.
No, the landlord gets punished by not getting the consent, not once, not twice, but 3 times.
It has no obligation to. You agreed to that in the guarantee.
It does under 11
literally
v.
said, I agree.
Counsel, Justice Scarpula does not usually need my help. She never needs my help. But you should never talk over a judge. So please let her finish the question.
You agreed in straightforward terms that my guarantee will not be affected by any modification of the lease, whether or not I know about it or consent to it. That's what you agreed to. No one forced you to do it. No one, maybe the landlord wouldn't have rented to you if you didn't agree to that. But then you can't get out of it by saying I had a fight with the tenant.
One more point. The general rule is especially true when the guarantee can be construed as open-ended and potentially having no specific end date, which is what this provision does. They could have changed, this could go on forever. I could still be liable now under that theory. This is
Counsel,
way too broad.
You have time in rebuttal. Thank you. Actually, you don't have time in rebuttal. I'm sorry.
Thank
But thank you for your presentation. Counsel.
Unless the court has any questions for me, I waive.
Thank you, counsel. Thank you all.
Thank you.
Burns v. RP1185 LLC. Please.
Good afternoon, Your Honors.
Afternoon.
May it please the court. My name is Lou Caracanuto, and I represent the defendant, third-party defendants, second third-party plaintiff, appellant, respondent, Global Precast, Inc. Global is a Canadian manufacturer of precast concrete panels. It was hired by the defendant, respondent, third-party plaintiff, respondent, Lend-Lease Construction, excuse me, to manufacture and install precast panels for the facade of the Ritz-Carlton Hotel, which was being constructed down on Lower Broadway.
Mr. Caratenuto, since we don't know yet exactly what happened, but Global had a role in designing and fabricating the panels, even though it didn't install it. The installation was done by the plaintiff's employer. Maybe we shouldn't, grant summary judgment for either side in this case. Isn't there an issue of triable fact?
I'm sorry, is there an issue of what, Your Honor?
Isn't there an issue of triable fact that would preclude summary judgment for either side?
I'm sorry, I'm not catching the word. Is that an issue of what?
Issue of triable fact?
Oh, yes, there's an issue.
Usually a triable issue of fact.
I mean, at the very least, the court, should not have granted 200 or negligence against my client, Global, based on the facts of the case. I mean, I do think we presented admissible evidence to establish that the accident was caused solely by the decision of our subcontractor to not make all of the connections to the panel and to have the crane release the panel at that time. And that's exactly what caused the the panel to fall, nothing with the manufacturing or the fabrication of the panel. My client clearly designed that panel. We were the only ones.
Well, didn't Gemco submit an expert affidavit indicating that the panel anchors did not meet the project specification, and that could be a cause of the accident?
Well, yes, Your Honor, that is correct. They did not meet the project specifications. However, the expert was able to testify that they did meet the New York Building Code specifications and the other, I forget the name of the other code. But the fact that it didn't rise to the level that the contract required doesn't necessarily mean that there was an issue with the design.
Didn't they have to do several workarounds around different panels over a period of time? In other words, that the fasteners weren't properly aligned, and they had to do some workarounds. So isn't that some indication perhaps that the panels were designed improperly or fabricated improperly?
No, it isn't, because that's a common occurrence. There's testimony and evidence, and there's common occurrence that the embeds don't always line up, and that's something that has to be fixed in the field. Doesn't mean that there was a problem with the manufacturing of the panel itself. Excuse me. And in fact, it was the obligation of Gemco, the installer, to make sure that the embeds were properly, put onto the building deck, as well as and that they lined up with the panels.
They didn't design the panels, right?
No, but it wasn't a design defect. It was something that needed to be fixed in the field if it didn't line up. This is like a common occurrence.
So on the Labor Law 200, Gemco says it's your design that caused the problem, and you say it's Gemco's installation that caused the problem.
Correct. And I think the evidence is that it is their installation that caused the problem.
So that leaves us with an issue of fact on the Labor Law 200, doesn't it?
Yes, potentially. I mean, the court did not find that. It found that they didn't care the lower court didn't care what the cause was. They just said you're responsible in 200 negligence, whether it was the manufacturer.
Of course, the more interesting issue here is that we also have an appeal on the 241.
No, 240.
240 sub 1.
Yes, yes, there's an appeal on that as well.
But plaintiffs saying that plaintiffs should have been granted summary judgment on that.
I'm saying that the court should have dismissed the 240 cause of action, correct? And the plaintiff is arguing.
The plaintiff says that plaintiffs should get summary judgment on that.
Right. Yes, I don't believe that they should. I don't think that they've met the burden.
You believe that the plaintiff should get summary judgment on 240?
No, there's a question of fact here. No, they should not get summary judgment on 240. They should not get it on 200. They shouldn't have got it at all.
Of course, if they did get summary judgment on 241, that would fall on you too, would fall on Global
Correct.
Also.
Yes, correct.
Okay, thank you. You have time in rebuttal. We'll talk about Gemco's alleged failure to procure insurance on rebuttal.
And the indemnification as well, Your Honor.
Okay, very well.
Thank you.
Good afternoon, Your Honors. My name is Scott Singh. I represent plaintiff, respondent, appellant. I don't know which.
So what is it that either Global or Gemco should have done to make this installation of the panel safe?
They should have made sure that the load was secured before the crane was detached.
And how would you secure the panel as it goes up on the wall? What's the device that you would use to safeguard against this fall?
Thank you, Judge Friedman. There was a tower crane that was being used, and that was supporting it. If they hadn't detached
it. They took it away.
They took it away. If they
And it
hadn't
fell.
detached it, it wouldn't have
But
fallen.
at some point, you have to take it away. So what do you have to do? What do you have to do to make sure that when you take it away, it doesn't fall?
I think the protocol is...
Is there a temporary
Yes.
device or
Yes, there is.
mechanism you use to prevent that fall?
Yes, Judge Friedman, there is. There's come-alongs and there's chain falls. And subsequent, after the accident, I guess pursuant to the Department of Buildings, they said you have to keep these in if you detach the tower crane. They shouldn't have detached the tower crane, but if they had detached it, they could have prevented the accident entirely.
Did they know that there was a problem that it was only attaching on top, right?
That's correct, Your Honor.
And so they knew there was a problem, but they did not take sufficient steps to see that it doesn't fall.
That's exactly correct, Your Honor, and that's why we think we're entitled to summary judgment on the Labor Law 240 claim. The cases all support it, and the fact that there was testimony that there were these three devices, crane, roustabout, not roustabout, chain fall, come along, that could have prevented it. That would have
Counsel,
supported
with regard to your 241 claim, we're talking about an object that fell. Do you actually have to plead what safety device would have prevented the object from falling?
It's not required. I cited some cases. I cited at least one case in the brief. There was another one that that was cited by our attorneys in Supreme Court. I didn't cite it in the brief, but it is there. Rubio against New York Proton, 192 AD 3rd 350. I'm embarrassed to say I argued the case successfully, but I forgot to include it. I didn't include it in my brief. But it supports the notion you don't have to show a specific device. But in this case, there was abundant
This is a
evidence.
summary judgment motion, so the record is going to cast some light on the subject.
The record casts a great deal of light because the record goes into the details about how the come along.
I didn't want to overstate things.
And thank you, Judge. How the come along and the chain fall. These are basically manually operated devices that could have done the job, and they were used afterwards. As far as the 200 common law negligence, I think the judge was entirely justified in granting summary judgment. And I just want to point out that they put in an expert, Nathaniel Smith, who ignored what the DeSimone, the company that prepared the report for the Department
If you prevailed on
said.
241, that doesn't really matter to the plaintiff, does it?
Yes,
It's more an issue. It's more an issue between Gemco and Global.
It is, but I just wanted to just point out this one fact that DeSimone said, due to the inward-facing lip of panel 208, the way it was fabricated, the installer was unable to adequately access the bottom lateral connection. He couldn't do his job. You'd have to reach in underneath the panel to do it, and there was too narrow a space to do it. And they completely ignore that fact, but it was...
So whose fault is that? Gemco or Global?
That was Global's fault, that it was fabricated in such a way that the workers couldn't do their job of securing it. You have to put two nuts in there. You need equipment to do it, and there wasn't enough room. But yes, I believe that if...
Gemco's experts say it was a design defect and not so doesn't that raise an issue of fact?
No, I agree with them. I don't think there's a defense to the design defect claim, in addition to the 240 sub-1.
Well, right, but if it was, but summary judgment as to Global on the 200 claim wouldn't be contradicted by a finding of design defect on Gemco's part, right? Or
Well, Global
I'm
was
sorry. Right. I got it turned around, yes.
I don't think that there can be more than one proximate cause of the accident. We believe that there was a design defect, and there was absolutely a failure to provide securing devices. So that
And this panel weighed 15,000 pounds, right?
Approximately, yes.
Thank you, counsel.
Thank you, Your Honors.
Good afternoon, Your Honors, and may it please the Court. I'm Gregory Turmel from Cerusi and Spring, and I represent RP1185 and Lend-Lease Construction respondents. So we believe that the Court should affirm the lower court's decision based on 200 and 241. I'll start off with 200. Global dictated the means and methods of how the panel should be installed according to the contract between Lend-Lease and Global. Based on that, Global is supposed to have a worker there at all times while work is going on. That was supposed to be the precast coordinator, Stephen Beraldo, who on the night of the accident, he left at 10 p.m. There's emails between Lend-Lease and Global showing that this was supposed to be their job, and they never did so. In addition to that, he was responsible for verifying the placements on the embeds, which, as I had mentioned, that email goes further into discussion about that.
You're talking about the common law negligence and labor law 200 right now?
Correct, yep.
Okay.
And then
Let's
in
talk about
addition,
240 sub 1.
240 sub 1, we're in agreement with the court below that neither party...
We know that. Why Why wasn't this a falling object case?
Well, we believe that the panel was already secured. I mean, at the time, they were obviously releasing it.
Obviously wasn't.
Yeah.
Well, they had secured it, but obviously maybe it hadn't been done to the extent that it should have, but they released it after a couple of minutes of it having been secured. They released it because they felt that it was secured at the time.
What about the fact that chain falls would have prevented this?
Well, plaintiff didn't point that out in their motion in the lower court, Your Honor. So we felt that we agreed with the court that neither the plaintiff directly pointed to a safety device that could have.
They don't have to if we're talking about a falling object, right?
No, we have several cases that we listed in the first department where it does state that you need to point to a specific device.
And we're talking about an object that has fallen, right?
Correct.
What cases are those?
I can get those for you, Your Honor, right now.
Don't worry about it. I'll look in your brief.
Thank you, Your Honor. And in addition to that, we feel that Global also did the same and not.
Counsel, you're suggesting that you can put up a 15,000-pound cement panel without securing it?
Well, as I stated before, Your Honor, they felt that it was secured at the time. That's why they had waited a couple of minutes before releasing it. And the workers who did it, these are people that have over 20 years of experience in the field. So if they felt that it was secured and that it could be released at the time, that's what they did. Obviously, it may not have been secured to the extent to which they believed, but at the time that the accident occurred, it had been secured.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court. I'm here for third-party defendant respondent Jimco. I would just like to focus on the undertaking part and the 240 part, because I think something that's important for purposes of, should come-alongs have been used, or is this a true falling object case, is it's the makeup of the panel, right? So you have this panel, it's massive, it's 15,000 pounds. You have two lateral connections at the top. In the middle, or closer to the top, but kind of in the middle, you have the gravity bars or the gravity connections.
We saw the photos, yeah.
Yeah, and then you have the three laterals in the bottom. So the actual weight of this panel is predominantly held up by the gravity bar. That's what the gravity bar is there for. It holds the majority of the weight of the panel. Then the top and bottom lateral connections have two different purposes, right? So you have all of the weight on this gravity connection. Then you have these top two connections, which those are meant, so the top controls the whole panel. It keeps the panel flush, and it basically reinforces that gravity bar, and it holds that remaining weight. So when you talk about these bottom connections, they're not weight bearing. The purpose of the bottom connections is to keep the panel aligned, to keep it flush and plumb, so that it doesn't swing in or swing out. So in this case, we had all of the weight bearing connections are made, right? So you have the two top connections made, you have the gravity connections, which are the most important connections made, and there's contradicting testimony about whether the middle bottom connection was made. So Jimco people said it was, plaintiff said it wasn't, the D. Simone, the structural engineering people afterwards said that it had been basically a partial connection. So at that point, then it's wedged in, right? Because they realize that because of the defect, because of Global's manufacturing defect, they can't do these other two bottom laterals. And so they wedge it in to keep it plumb. And then...
That's when they use like the shim-like material?
Yeah, shims or wedges. So then once that's done, the panel is installed. The undertaking is complete. So then at that point, to make sure that they didn't screw anything up and that it's safe to
You're saying it's done at that point? The shims are obviously temporary material.
Shims were temporary. Done might not be the correct term. It's finished for the purposes of until they can get that fix for the defect from Global. So then to check it, they release half the weight. And they wait 2 to 5 minutes and nothing moves, nothing happens, it's fine. So then they release the weight, they're done, they start packing up and getting their tools to move to the next thing. And the panel doesn't fall for 10 minutes after it's
What follows from that though, counsel? It still fell.
Well, I think what follows from that is that the fact that it fell, even though those gravity connections were made and even though those top weight-bearing connections were made, that shows it was an issue with the fabrication itself, not the way that it was hung. You know, and when they went back and they were
I mean,
making.
what if it fell 20 days later? I mean, that's 28th Street, so a lot of people, that's a flower district, you know, a lot of people walk there.
Yeah.
You know, so if it falls in 20 days, that still could be possibly on Gemco's installation, no?
I mean, I think.
I mean, in 10 minutes, for sure, it's definitely on you. It seems like, I don't know.
I mean, at best, I think it's an issue of fact, but I do think that, you know, the experts and the DeSimone analysis and also just the witness testimony, you know, the Gemco guys have decades of experience. They looked at it and immediately one of them, he said something like, I realized immediately it had been, like, it was just horribly wrong. The panel was horribly wrong as far as it was manufactured.
All right.
So I think it points to a defect in the manufacturing as opposed to the installation.
Understood. Thank you.
Just a couple of things, please. The New York City Building Department directed DeSimone to investigate the cause of the accident. DeSimone concluded that the panel fell because it did not have all the required lateral anchors connected at the time the crane supports were released. That's what they said. There is discrepancy as to how many connections had been made, but the only person who knows how many is the plaintiff. Everyone else is speculating because the plaintiff was doing the connections and was the only one who could see it. The other two Gemco people were standing on top of the panel, standing inside the building, could not see what the plaintiff was doing. So the testimony is none of the bottom connections were made. This thing about the lip, the being, you know.
Are you arguing that the plaintiff caused his own accident?
No, I'm saying the cause of the accident was the fact that they didn't make all the connections and they released the crane. And it was not the design.
And that wasn't plaintiff who released it without.
No, plaintiff didn't direct the release of the crane. No, absolutely not. It was
So
the
then
foreman.
I'm unclear. Why is this? What relevance?
Because
I guess,
it's
as to-
relevant in terms of my right to indemnification.
Oh, and I thought you were talking about.
Yes. No, I'm sorry. I should
200 or
have made
the
that clear. Yeah, because that's our position. It was sole proximate cause was Gemco, the way they installed it. They released the crane. I mean, the crane was still there. You know, they could have left it hanging from the crane. That was the safety device. And they just disconnected it. This inward-facing lip thing, though, I want to talk about that because there's a lot of discussion about it, that was why the guy couldn't make the connection, why the plaintiff couldn't make the connection. That's not true. The plaintiff said why he couldn't make the connection. He didn't say because there was no room to do it. He said the embeds didn't line up. He's the one who knows why he couldn't do it. And the reason the embeds didn't line up and the responsibility for making sure they lined up was Gemco's. We subcontracted the entire scope of the installation to them, including the supervision, the representatives that have to be there, the equipment, all that. That was on them. I have an indemnification clause in my contract. It has the saving language in it. It has no negligence trigger, and I'm entitled to that. I'm also entitled to insurance. The court incorrectly concluded that they did not breach their contract. They failed to provide me with the insurance that was required under the subcontract, which they should have. You know, they probably thought the OSIP covered it, but as we know, OSIP disclaimed the coverage based on a manufacturing off-site condition.
Thank you very much, Counsel.
Thank you.
Thank you, Your Honors. As far as the Labor Law 240, the court is well aware this is an absolute liability statute. So if somebody miscalculated and detached the crane too soon, that's not an excuse, and they're liable under the statute. So, and as far as
Is the 10 minutes relevant to that?
no, it's not. It was the cause of the accident. The absence of
the
absence of the lateral connections was the cause. As far as Global's role, they had responsibility to inspect to make sure that these panels were aligned, number one. And they also had to have somebody, a competent person present on the job, and he wasn't there, he left. He mysteriously left at 10 p.m. He wasn't there when the accident occurred. So they're in, I think, on the 200 common law negligence. But certainly, absolute liability under Labor Law 240, there's no defense to it. And we ask that Your Honor modify the order appealed from accordingly, unless there are questions.
Thank you, Counsel. Thank you all.
Thank you very much.
Martin v. William and Cindy Abrams Family Trust.
Good afternoon, Your Honors.
Afternoon.
Robert Friedman for appellants. May it please the court, counsel. In 2016, the shareholders of MSI decided to change the 2010 shareholders agreement in two major ways. The first is that because of what had happened with one of their shareholders, Joel Goldstein, who was not working, who essentially was not working but was receiving all the benefits of an equity holder, they decided to change that mechanism so that shareholders would have to also be working, as is common in most law firms, as is common with most management companies, small companies, accounting firms, etc. Nothing.
Right. So then Martin and Badari,
yes, and
both got 25%. Got from his. 50%.
That was the second major. Is Mr. Goldstein exited, and my client Zara Badari and Terry Martin, the plaintiff, became equity shareholders in 2016. So those were the two main changes.
And they shared the same lawyer at that time, right?
Yes, they did. Yeah. Yes, they did. Mr. Schechter, who subsequently abandoned Mr. Badari, and during the pre-litigation and during the litigation. So
they came up with paragraph 3.5.2.
1.5.2.
1.5.2.
Yes.
Sorry.
How does that accomplish? I'm sorry.
Please, no, go ahead.
How does that accomplish the issue that you said was the problem? How does the language in that provision accomplish that, having a shareholder who's also working?
Well, because it says for so long as they are shareholders, they will be serving as XYZ, and it's for all of them. It's not just Ms. Martin and Mr. Badari. All of them had the same obligation. You are going to be a working shareholder. For so long, and it's important, the first part of it says, for so long as you are a shareholder, you shall be. So if this wasn't to accomplish anything and it's just a title, as plaintiff argues.
But it doesn't say if you're not fulfilling the duties of those titles, that you're no longer a shareholder.
Right.
Well, it basically says it from the first
around,
part.
but it just doesn't say that.
It doesn't say what you're purporting it to say. It says the opposite. It says so long as you're a shareholder, you have you can also be these positions in the company. It doesn't say that if you're not a shareholder, or if you're not working as these different positions, CEO, whatever, that you are not permitted to be a shareholder.
The plain language says shall. It does say it does not say can. So if you read this together, it says so long as you are a shareholder, you shall be performing these services. I don't think it could be, frankly, any clearer than that. Otherwise, you would not need that first part.
What about the fact that the draft 2013 agreement had the express forfeiture language, but the 2016 agreement did not?
It's a great question, and this is one of the reasons why this needs to go back to the trial court, because the trial court ignored there's a dispute on evidence here with respect to the 2013. The evidence from Mr. Abrams, Mr. Bandari, and Mr. Garfinkel is, especially Mr. Abrams, is undisputed, that they say that this forfeiture provision was because when they were considering the question in 2013, Mr. Bandari and Ms. Martin were not paying for their shares. It was purely a Section 83 tax issue. Very clear in the record. Mr. Abrams, who is a tax lawyer, said, hey, Terry, Zara, if we're going to hand you shares and you're not going to pay for them, you're going to get hit with a tax. There's going to be a big tax issue for you. So therefore, we have to put a provision in there that gives you a loss, and that will, under the tax code, consult your own advisor, but under the tax code, that will be, at least in Mr. Abrams' view, remedy the situation. All of the witnesses, it's the most important point here is all the witnesses, there is not a scintilla of evidence that this was a draft, a quote-unquote draft, as found by the trial court below. In fact, there are so many differences here. Mr. Bandari
Thank
and
you,
Ms.
Counsel. You
Martin
can
were not...
unpack those on rebuttal.
Sorry?
You can, I've given you a lot of extra time, so you can unpack those differences on rebuttal.
Yes, thank you.
Thank you, Your Honors. Good afternoon. Scott Sherrick on behalf of plaintiff and respondent, Ms. Martin. I thought I might just start out with a point that is actually something that we all agree on here. And when I say we, I mean the respondents, the appellants, as well as the Supreme Court below. And that is that in the MSI shareholders agreement, in all of its 30 pages, it does not address a shareholder's retirement, nowhere. Nor does it address expressly the question of a potential forfeiture of a shareholder's interest anywhere, whether that's a complete forfeiture or a partial forfeiture. The word forfeiture or even any analogous words appear nowhere in the agreement whatsoever. So the agreement is completely silent on both of those issues. There's universal agreement on this point. So the fact about which there is consensus necessarily means that with respect to the 13 words in section 1.5.2, which is the sole provision on which the appellants hang their hats in this entire agreement, do not include any discussion about retiring, what happens with retiring shareholder shares, nor does it say forfeiture or anything like that.
Why doesn't it mean, to pick up on your colleague's point, that if you're a shareholder, you've got to be working?
It does not mean that, Your Honor.
Does the word "she shall serve" mean that if you're a shareholder, then that means that you shall serve also in those other positions?
No, it does not, Your Honor. So in construing section 1.5.2, the Supreme Court held that you can't reverse that statement, right? So the Supreme Court said it doesn't say so long as she is CEO, she shall be a shareholder.
And certainly, I'm sorry, and
sorry.
certainly we start with the well-established rule that in order to have a forfeiture, you have to say it's a forfeiture. So in rules of construction, there's nothing in there that talks about forfeiture, so you would not normally interpret that statement.
And that's exactly correct, Justice Scarpula. And that's the centerpiece, frankly, of
you don't give up the shares.
They go on to say it's not a forfeiture because they could have sold it to third parties, her 25%. What about that?
That's to use the hackneyed phrase, complete red herring, Your Honor, because in fact, what they say is, well, she could have sold it before she retired, but that now she's retired, she forfeits, quote unquote, shareholder benefits, which is just a euphemistic way of saying that she's not going to get any shareholder distribution. So what good is it to own stock that you can...
worth if she's not working? If she's working, she draws a salary. If she's not working and not drawing a salary, what are the shares worth, practically speaking?
The distributions that attach to them, Your Honor. There are substantial distributions that come, just like being a shareholder in any corporation, regardless of the size, you're entitled to whatever distribution.
Let's see if everyone's wages have to be paid.
I'm sorry, I didn't understand.
Let's see if everyone's wages are paid.
Correct, Your Honor. That's right. It's the distribution of profits that remain in the company after all the expenses are paid and other expenses are reserved for, et cetera. And to answer Justice Moulton's question, that is their position. Their position is that she not only would have forfeited the shares themselves, but now that she's retired and no longer working, under their interpretation, she forfeits the right to distribution. So either way, there is a forfeiture here, whether explicit or implicit in the defendant's position or in the appellant's position, which triggers the law that Justice Scarpella is referring to.
And because there are specific provisions that provide for mandatory disgorgement of shares if she dies, or right.
That's correct.
It's not like they didn't understand that they could have put in a situation where she would have to give up her shares, because they put it in for death and permanent disability, right?
That's correct.
So that's a mandatory. You got to get rid of your shares if you die. So we don't want anybody else in the company that we don't know, which is pretty common. And we don't want, if you have a permanent disability, you've got to give up your shares.
And
It
that's
says nothing about if you retire.
That's correct. And I see my time is up, but I'll just add in the same vein, if I may, that the 2013 draft that my colleague was referring to, the same point applies there because there is an express forfeiture provision there. And that the primary drafter of that document was the same drafter of the 2016 document. So we know that he knew for sure how to draft a forfeiture provision if it was
Although the
required.
court said it didn't rely on parole evidence, right? And we have,
Our
we have
position-
no reason to think it did when it said it didn't.
Absolutely. Our position clearly, Your Honor, is that this is, as the Supreme Court said, a decision that can be made on the four corners of the document, just applying New York law and contract interpretation.
Thank you, Counsel.
Sorry.
I just want to pick up on the last point, Justice Scarpello, that you made. All of the issues that you raised, those were sharp factual disputes in the underlying record that the court just made a determination.
I don't know if whether or not the forfeiture, I think the document either says you forfeit your shares if you retire or it doesn't. And that is not something that is subject, we can all read the document. If the document says you forfeit your share upon death or not, it's in the document. It has nothing to do with parole evidence.
There was a difference, and all the witnesses testified.
And
Sorry.
just one last
Yes,
thing.
sure.
The common law rule that without express words of forfeiture, we don't ever say there's a forfeiture. You don't need parole evidence for
Okay,
that, right? And those are the three things the court below relied on, right?
And here's what the court did not address, and that is 4.2, which is what Justice Moulton pointed out. There is not a case. You can go through all the cases cited by both parties, including the tree bark case from the 1800s. There is not a single case where there was an alternative where the court found that it was an improper forfeiture. Here there is an alternative. And this was exactly what the parties negotiated and agreed. If there's going to be a voluntary step back, then you go and try to sell your shares in 4.2.
It says nothing about voluntary step back.
But
absolutely not, correct? That's
no,
you putting words into the agreement that are not.
No,
Show me where it says that.
In 4.2.
Show me where it says if you are voluntarily stepping back, you have the opportunity. We get the right of first refusal. Show me where it says that.
It doesn't say
Of course it doesn't.
But it does say if you read 1.5.2 with 4.2, that is the formula that the parties agreed to, which is you shall serve. If you are a shareholder, you shall serve. And if you want to voluntarily step back, as opposed to a disability or a death, if you want to take a voluntary action, then go to the market. Go to the market.
But the agreement doesn't say that, right?
If you read those
1.4 is 3 and 4.2 are
1.5.2
3 sections away from each other, right? It doesn't. They're not connected.
They're not connected by any language in the contract.
Well, you know what's interesting? You know what's interesting is if you look at the transcript below, Justice Maisley found that 1.5.2 connects the shareholder and the shareholder and the service. She specifically found it if you read the record. And I'm unaware of a contractual, of a law that says, or a ruling that says, if you look at all of the provisions, you have to specifically connect them. In fact, New York law is the opposite. You read all the provisions together. And when you go through the evidence below, the witnesses, it's a sharp dispute here. This is summary judgment. Again, this is not after trial. And most of the cases that plaintiffs cited are after trial relating to forfeiture. Because really what this is a draconian result where you're saying, okay, the parties said 1.5.2, but we're going to disregard that. We're going to disregard 4.2. We're going to disregard the first part of that, which says, so long as you are a shareholder.
Thank you, counsel.
Thank you.
Thank you both.
Thank you.
People v. Morris.
I don't know.
please.
Good afternoon, Your Honors. Victoria Wu, Office of the Appellate Defender for Tyshawn Morris. The CPL 3030 motion should have been granted because 2 additional periods of delay were includable. At both junctures, the
What about court congestion during COVID, counsel? Isn't that a sufficient excuse for those delays?
No, Your Honor, because the Court of Appeals has held that in order to exclude delay based on court congestion, the prosecution must be ready for trial. And at both junctures at issue on this appeal, the prosecution failed to maintain trial readiness. So as to the first period from June to September 2021, that period was includable because even though the prosecution answered ready on June 21, 2021, it actually failed to produce Mr. Morris to court on that date. And the Court of Appeals has held...
Did his lawyer waive his appearance?
So, Your Honor, that argument is both unpreserved and meritless. The prosecution below did not argue that the waiver of Mr. Morris's appearance somehow excused a failure to produce to court on that date. And in fact, as the
What
motion...
was the record about why he wasn't produced on that day?
So the record was extremely sparse. There was only a statement that the Department of Correction did not produce Mr. Morris to court on that date.
Right, so the people had set up for him to be produced, but Department of Corrections did not produce him.
Correct. But again, the Court of Appeals has held that the failure to produce an incarcerated individual means that the prosecution cannot be ready for trial on that date. The presence of a defendant is an absolute prerequisite to trial to begin. And on this appeal, I think respondent has now raised this new argument that they exercised diligence in trying to produce Mr. Morris, but that argument is also unpreserved and meritless because the record doesn't establish any details about what efforts the prosecution made to produce Morris to court on that date. And so because the prosecution did not produce Mr. Morris to court on that date, its declaration that it was ready for trial was actually empty, and the ensuing delay was
Was that
chargeable.
argued in the 3030 motion that the people failed to produce Mr. Morris for trial?
I'm sorry, I didn't catch it.
Was that argued in the 3030 motion by defense that?
Yes, it was argued both in the opening motion and ultimately in the reply papers as well, that because the prosecution had failed to produce Mr. Morris on that date, the people could not have been deemed ready for trial on that date, and therefore the delay was includable.
But wasn't the court not ready?
So again, the Court of Appeals has held that court congestion does not relieve the prosecution of its obligation to maintain trial readiness. So even though the court was anticipating congestion, in order to exclude time...
On post-readiness delay? On post-readiness delay?
Yes. So the Court of Appeals made that very explicit in its decision in People versus Labat, which was from 2024.
So what were the people supposed to do when the court tells both parties the court's not going to be ready to go forward?
So at that juncture, I mean, the Court of Appeals has held that court congestion does not relieve the prosecution of its duty to maintain readiness. So I think under that ruling...
I don't understand but what we're asking you is if the court says, you're saying to us, the court tells the parties, I am not going to be available on that day. You're saying that the people still have to have the defendant produced, even though the court says that?
Well, you know, they could perhaps ask for the consent for the defense. Are you going to
And they did, and defendant consented, waived the appearance, right?
Well, consent as to the exclusion of time, which is at issue.
What are the people supposed to do when the court tells them that they're not going to be ready?
Well, I mean, again, I think the Court of Appeals has already said that court congestion does not relieve the people of its duty to maintain readiness.
But I don't think Labat says that they have to produce the defendant, even though the court has said nothing is going to happen. Labat definitely doesn't say that.
Well, Labat does say that the people have a duty to maintain readiness even in the face of
that doesn't mean that you're arguing the reason why the delay should be attributable to the people is because they didn't produce the defendant. But that's not what happened. The court said, I'm not ready. I can't do it.
No, the prosecution answered ready on June 21.
Right.
But that declaration was empty because they had failed to produce the defendant.
But I don't think what you're appreciating is that the court was also not prepared to have a part for the defendant, for the parties?
All I can say is that the Court of Appeals has instructed us that court congestion does not relieve the prosecution of its duty to maintain readiness.
The people were ready.
They could not have been deemed ready because they failed to produce the defendant to court on that date.
Thank you, Councilman.
Good afternoon, Your Honors. Jacob Marcus for the people. As Your Honors have pointed out, this was a case during the COVID-19 pandemic where there simply weren't court parts for a defendant's case to move forward. This June 21st was a virtual appearance where the parties tried to arrange for a defendant to come, but DOC was unable to provide him with a space to get on the virtual appearance on Rikers Island. That isn't attributable to the people.
So do you agree with counsel that simply because the defendant wasn't able to appear, not because the people didn't try or because the court was congested, that time has to be charged to the people?
It should not be charged to the people, Your
But what about the people making a record as to, at that time, as to your diligence with trying to ensure that Mr. Morris would have been produced for that virtual hearing? Did that happen?
Well, I don't think we needed to make a record as to diligence in this case, right? The cases that say the people can maintain readiness without a defendant there when they show diligence, or when like defendant's in Connecticut or he's in federal prison and it's possible to get him there. Here, the court said DOC cannot produce defendant, so I don't think it was necessary to make that kind of a record. Again, to point to the actual language of Labatt and Goss and McKenna, it says people's unexcused failure. Now, opposing counsel relies heavily on England, which seems to suggest a more blanket rule that defendant has to be there. That's the end of the story. But they sharply circumscribed that in People v. Goss. They said that was a limited rule, and then they used more expansive language that said delays that's wholly attributable to people, delays that are solely attributable to people. So here, where defendant wasn't there by virtue of this really fact-specific circumstances in the COVID-19 pandemic, the people shouldn't be charged for that. In fact, that would be inconsistent with the purposes of 3030, which the Court of Appeals has said is a statute designed to prevent prosecutorial inaction. Here, the people did what they needed to do to be ready, and DOC was unable to produce that. So that's not an unexcused failure.
And People versus Goss says it has to be the people's dereliction, right?
Yes.
Not dereliction. Right? Not because DOC couldn't produce during COVID a space for the defendant to be there. It has to. The defendant has to show that it was or there has to be evidence that it was the people's dereliction.
That's correct.
And there's none here of that, right?
I agree, Your Honor. Now, because of the nature of this 3030 claim, defendant does need to prevail on both disputed adjournments, and because I think it's squarely attributable to court congestion as to this June 31st adjournment. We don't need to move to the January 7th one, but I will just note that in that case, the people relied on the court statement that the case would not be going. I think, as Justice Friedman alluded to, it would be kind of absurd to expect the people to haul 12 witnesses to the courtroom for a calendar call that they had been told would not be a hearing because of the ongoing health pandemic. So if Your Honors have no further questions, we ask that you affirm.
Do you want to address the warrant issue?
Yes, Your Honor. The warrant was sufficiently particularized and timely executed. So to start with execution, because I think that's the simpler question, this court's precedent in Ruffin and Blue squarely says executed upon issuance. Here, we're not even asking that much. This was executed upon delivery to the forensic laboratory, which is consistent with the nature of analysis of digital evidence. With regard to the particularity requirement, this is something where applicable, the seizable evidence was circumscribed by temporal limitations, and there was a 2-page long illustrative list letting officers know what they could use. Just because it does have a broad mandate to look at all data on the phone, that's just what courts would expect from searches for digital evidence, where it's necessary to copy an entire hard drive and look at least cursorily through everything in order to determine what is responsive and what's not. So we ask that you affirm. Thank you.
Just a couple of
So you said that the people are chargeable for not production. Didn't the Court of Appeals say in People versus Labate, once the people announce they are ready for trial, a post-readiness delay due to court congestion is not chargeable to the people when they were ready to try the case, but the court or defendant was not?
So I think Labat also says that charging post-readiness delays to the court means that the people must have been ready for trial at that juncture. So that clarifies.
Weren't you people ready for trial here?
So for the June period, they were not ready for trial because they failed to produce.
There's no indication that the people's readiness was pretextual or anything like that. They're told by the court, I don't have a part for you. Do they have to produce witnesses?
Yes, under what the Court of Appeals has held. I mean, People versus England says that the people cannot be deemed
The Court
ready
of
for
Appeals
trial.
requires them to bring the witnesses to court, even though it's been unequivocally relayed to the people that you're not going out.
I mean, again, I think this goes back to your earlier question of what is the prosecution supposed to do. I think in that juncture, they could potentially ask the defense to consent to excluding the time, to waive their 30-30 rights. Look, the court is not going to be ready.
says
But
no?
they never tried to do that.
But what if the defendant says, no, I'm not going to waive it?
And I think this goes then to the larger policy question of why the Court of Appeals has insisted that the prosecution maintain readiness even in the face of likely court congestion. And that is because...
this case, it wasn't likely. If we're just constraining ourselves to the January 7, 2022 adjournment time period, it wasn't likely. The court indicated that it was not going to be able to move forward and that there were no parts for the...
So actually, Your Honor, on the date itself, the court said that my calendar had actually freed up. It was ready to...
On that day, right? But prior to that, you're talking about having multiple witnesses come in and the court telegraphed to the people beforehand that it wouldn't be ready. But on that date, on the day, changed its ability to be ready.
Yes, and so I think that is why the Court of Appeals has insisted that the prosecution maintain trial readiness, because the court's calendar can free up. In that case, the case can move forward.
But the Court of Appeals has said that once the people announce that they are ready for trial, a post-readiness delay due to court congestion is not chargeable to the people.
But charging that delay to the court can only happen if the people are ready for trial. And as to both periods here, the prosecution was not, and therefore the exclusion of the delay on the basis of court congestion was error. And for that reason, the motion should have been granted. Thank you.
Thank you both. We have your briefs. Thank you. Keel versus Kavikio. Kavikio. Counsel, did I pronounce Mr. Keel's name correctly?
I'm sorry?
Did I pronounce Mr. Keel's name correctly?
You most certainly did.
Is it Kavicio or Kavikio?
Kavikio.
Okay, thank you.
Kavikio, Judge Moulton.
Please.
Thank you. May it please the court, Stuart Kagan on behalf of plaintiff appellant John Keel. The trial court below erred in dismissing on a 3211 motion to dismiss Mr. Keel's first through fifth causes of action, which all related to his claims for breach of fiduciary duty and joint venture. The reason for this error is understood holistically in context, because under governing Massachusetts law...
Is there a conflict between governing Massachusetts law and New York law?
Yes, yes, Judge Michael, there most certainly is. Under New York law, it is generally required in this department and elsewhere that an agreement to share losses is required to show a joint venture, whether oral or otherwise. Here it is oral. That is not the case in Massachusetts. Most specifically, we have cited to you multiple Massachusetts cases in which the trial courts there have found, absent any agreement to share losses, that a joint venture agreement was properly pleaded and was permitted to go forward to trial.
It's something you can look at, even in Massachusetts, right?
I'm sorry?
You can still look at it. It's one of the factors in the Massachusetts test, not at all?
Absolutely, Judge Moulton. It is, in fact, the seventh factor in the Shane 8 multi-factor test.
Right.
And most certainly it is a relevant factor.
Let's put the sharing losses aside for a moment. I mean, you have other issues, which are multiple. The purchase of real estate for Soundtrack was done entirely by Mr. Kavikio, right?
I believe that is correct, Your Honor, yes.
Okay. What else have you got to show that besides, I mean, it seems to me you have a few oral statements over the years that show certainly that Mr. Keel was a valued employee and very important to this business, but I didn't see it adding up to a joint venture.
So, Your Honor, to answer the question, I'm going to assume that the court is in agreement that Massachusetts law applies here.
You shouldn't assume that, but let's go ahead.
So
we're not sure there's a conflict, but
okay,
we'll consider that.
Well, I want to, if there is a conflict, I want to discuss the issue, but let me put that to one side. I want to run through the 8 factors that Shane holds are relevant in determining whether or not a joint venture is here. The first is whether or not there is an agreement, common agreement between the parties, joint manifestation to attempt to obtain profit. That most certainly is the case here. These 2 individuals were the only people that worked at Soundtrack over the lifespan of this company from inception to the date, to present date, from 1977.
Is there any evidence in the record that your client was sharing in profits versus getting paid?
Yes, Your Honor. Yes, Your Honor. This was alleged both in our complaint and in the record at 640.
But what we have in the record is that he received multiple W-2 statements which comport with him being paid a salary, not him getting any profits.
It is also compatible with the inference, and all inferences on a 3211 need to go in plaintiff appellant's favor. It's also compatible with his receipt of profits. And in the record at page
W-2s?
I'm sorry?
W-2s?
The receipt of profits from the W-2s.
W-2s are consistent with receipt of profits?
Yes, Your Honor, they can certainly be, because in this particular case, the allegation is that the amount that was paid within the W-2s was based upon the profits in the company, which was, as we allege in all our allegations.
A partner gets a W-2?
I'm sorry?
A partner gets a W-2?
Partners can get W-2s. It is not required that they get W-2s, but they can. There is no requirement in Massachusetts or frankly in New York law that anyone need to receive any document other than a W-2. There are issues about what statements are made in tax returns.
No, that can't be, because you cannot get profit from a business in a W-2. That's just not the way that a business, any business, can account for it. So you would have to either have a 1099 or a partner or some partnership.
K1,
right? You cannot call your business profit.
The allegations in our complaint, which need to be taken as true, specify the means of payment of the profit.
They only need to be taken as true unless they're disputed by documents which are 3211A1.
Most certainly.
They are. Here are W-2s.
Most certainly not, Your Honor. There are no 3211A1 documents present in the record here. Nothing was disputed. That is in error. With regard to the profits, the allegations which need to be taken as true were 1, that profits were taken and paid through the W-2, and 2, that at the time of his retirement, the parties had an oral agreement that Mr. Keel was to receive the remainder of his profits in a payment, not in a W-2. That is sufficient for purposes of overcoming the motion to dismiss.
Thank you, counsel. You're in rebuttal as well.
May it please the court, Patrick O'Toole for the defendants. Your Honor, I guess I'd first like to begin with the idea of the conflict. We think that the court would correctly dismiss the partnership and joint venture rules. The idea that there's a conflict is incorrect. Both Massachusetts and New York require a sharing of losses. The only case that either party has found that would suggest otherwise is this Ramey case that plaintiff has cited. It's a Massachusetts Superior Court decision. It's not controlling in Massachusetts, and it's not controlling here. It's never been cited or followed for that proposition. It's a complete outlier in Massachusetts law, and it's not consistent with the appellate teaching. In fact, when you drill into Ramey, the trial court looks at the Shane factors, and the 2 points that the court suggests are missing are sharing of losses and control. Those are two of the four Gurry factors. And in Shane, the appellate court case, those are the two items of the checklist that Shane highlights as most important.
Counsel, do we have any evidence of sharing of losses in this case?
No, there's no sharing of losses, Your Honor.
What about profits? Were the W-2 statements?
Excuse me, Your Honor. He received a salary and he received a bonus and commissions. And the commissions were paid to a separate entity, and those were a part of a profit sharing. And we have a whole bunch of cases within our brief that show that an employee receiving bonuses or commissions based on profit does not make you a partner.
What about his statement that he took a 50% cut on his salary when the company was experiencing lean years? And does that create some sort of sharing of loss?
No, Your Honor, and I think that's if we look at his specific allegations about what sharing of losses are, first, it's an agreement to share losses. And that alleged pay cut happened in 2016. And even in the amended complaint, he says it was paid back, or mostly paid back. There's some dispute, I guess, about the amount. The fact is that if you're an at-will employee, your pay can get reduced. It also speaks nothing about an agreement to share losses. This 2016 reduction in pay, temporary pay cut, essentially is what's been described. The allegations here is somehow there was an agreement starting in 1977, so some 40 years or how many years.
What about his claim of investing in the company with regard to the equipment that he leased or that he purchased?
Thank you, Your Honor. Partners leasing, we've attached those documents. And that demonstrates that that was a series of separate joint ventures between plaintiff, the defendant, and other Soundtrack employees in 1995, 96, and 2002. It's a separate venture. There's a written agreement that says this is a joint venture. In addition, the complaint indicates or admits that it was a profitable investment. There's no sharing of losses based on that. That's our point, Your Honor, is that we think the Massachusetts law, we cite all the controlling cases, all which cite to New York case law, key New York cases on indispensable requirement or the essential nature of a loss.
When does the plaintiff allege that the joint venture was formed?
I believe it's difficult, Your Honor, because we believe that what he tries to argue is that it's actually he tries to argue it's a partnership. And a joint venture in Massachusetts, like New York, is generally for a limited undertaking. Here, if you read the complaint, there, as I think the Justice had referenced, there's various discussions of statements that he alleged shows intent or something like that. And it's really hard to tell. I think we cite in terms of the choice of law section, some case law that talks about when you have an oral agreement and it's made up of all of these statements made at different times in different areas, hard to pinpoint location. But I would suggest that the
requirement to say when the joint venture or the partnership is created?
Yeah, I believe he suggests 1977 for the partnership, Your Honor.
Okay.
But
you're saying now that he's alleging a partnership and not a joint venture?
Yes, exactly. He's initially, we believe, a focus that was an alternative argument. And then he moved on to now the joint venture. I'll stop.
You'll have time in rebuttal, counsel.
Okay,
Thank you.
Thank you, Your Honor.
My colleague tells the court that Massachusetts law, there's no case in which a joint agreement to share losses doesn't exist. There isn't one where joint venture is pleaded, and that's all we are at here, at the pleading stage, that you can't plead a joint venture unless you also plead an agreement to share losses. My colleague is mistaken. His own cases betray his error. Over 100 years ago, in the Canberra case, C-A-M-B-R-A, which is cited in my colleague's brief, the Supreme Judicial Court of Massachusetts upheld the claims of a partnership and potential joint venture with regard to an agent of a ship who only had 5 shares of the company. No agreement to share losses whatsoever. That particular case was a tort case. The issue in that case was that the ship staff were suing on the basis of negligence because they had been harmed by something on the ship. They were suing both the owner of the ship, who was the captain, and the agent, who was merely an equity holder of merely 5 shares, a minority equity holder. And they said, he's in partnership and joint venture under Massachusetts law. There was no agreement to share losses whatsoever. The Supreme Judicial Court of Massachusetts permitted that to go to trial, which is all we seek, trial. And at trial, it was held that he was not, in fact, a partner. But it was pleaded, and properly so.
Counsel, how do you distinguish Gurry versus Cumberland Farms, where the Supreme Court said the key requirement in finding the existence of a joint venture, agreement among the participants for joint profits and sharing of losses?
I absolutely agree with that.
So that is a key requirement for a joint venture. So tell me, at the time the joint venture was, what have you pled? Well, first, let me just ask you, when do you plead the joint venture was created?
It is specific. Despite my colleagues' statements to the contrary, we allege specifically that the joint venture was created in an oral agreement between the two parties in 1977 in Boston, Massachusetts.
What were the specifics? Sorry.
In the specifics of that agreement, the two individuals agreed to start a music-producing company, and it was rather concrete. Mr. Kavikio has no abilities whatsoever in the music business, and he never ran it, operated it, or had any skill in it. Mr. Kavikio, on the other hand, did. So the agreement between the two parties was that Mr. Kavikio would handle the business side, and Mr. Keel would do the actual business of the company, create the music, and that was, without question, not disputed at this point, the business that they followed for some 40-odd years.
And what did they say about sharing the losses in 1977?
They did not say anything about sharing losses. And as I have said before, under Massachusetts law, that factor is one of many in a holistic manner. The Canberra case, which is from the highest court in Massachusetts, held that it was properly stated with no sharing of losses. The Ramey case also found the joint venture was properly pleaded with no sharing of losses. And I want to note that my colleague, in his reply brief at page 8, states that the Ramey case never holds that you can find a joint venture properly pleaded without an agreement to share losses. But if you actually read the Ramey case,
We'll do so, counsel. Thank you very much.
And take a look at it, you will see that Ramey says that 4 of the elements of joint venture are properly pleaded, but the 7th element, which is the sharing of losses, is not. And that's because the Ramey case involved an individual and executive.
Thank you,
who
counsel.
received-
You do talk about that in your brief. Thank you.
I understand, but he received a W-2.
Counsel, thank you.
Understood. Thank you.
Thank you, Your Honor. And just to lead back on the point of sharing of losses, there's a stream of appellate cases from Massachusetts, Cardullo. It cites Hutchinson, which is a New York case that says you need sharing of losses in addition to intent.
An agreement at the time the joint venture is entered into, not just proof that 30 or 40 years later someone took a cut and pay.
Yep, exactly. And then Ear Technology, they cite to Steinbeck, which is the leading leading New York case on the indispensable requirement.
What about the unjust enrichment claim?
Oh, you on the cross appeal, Your Honor? Thank you, Your Honor. On the cross appeal, we think that those claims should be reversed for a couple of reasons. One is unjust enrichment. It's not a catch-all claim, Your Honor. It focuses on the benefit that's received.
But he says, I gave money to the corporation and I didn't get it all back. Maybe it's $12, but that's unjust enrichment, right?
Except here, it seeks restitution. I think that's a great point, Your Honor. In his complaint, though, he's saying the benefit that we're not entitled to is the profits and the real estate. But when you look at what he gave, we've shown that.
Well, couldn't a benefit be the money he didn't take from his salary that he said or the money he lent to you that he said you didn't pay him back? Benefit's a pretty broad word. So there might be something there to that, right?
Except it has to be a benefit we're not entitled to.
Well, you're
that
not
is
entitled.
expensive.
If you borrow money and you don't pay it back, you're not entitled to it. Right?
Except here, he's focusing on the idea is the profits and this real estate. And that the court found he's not a partner, he's not a joint venture, he has no interest in that. And then also it has to be at his expense. And he tried to, for what he says at his expense, he says partners leasing. Well, that's a different entity. It's a written agreement. It knocks out the quasi-contract claim. And also the $47,000 that he alleges it's conclusory. There's no suggestion it was ever agreed to, that he ever asked for it back, that it was. And it was also put in over a course of 20 years, and it started in '82, Your Honor. So unless there's other questions, thank you.
Thank you, counsel. Thank you both.